beg your pardon to mention before mention. Your Lordship's item number 66. Your Lordship, the conducting council met with an accident. I prefer
See that. Don't worry.
Lordship.
Pardon to make a mention for modification.
Sorry.
For modification.
Take it down. 79.
Last operating
On a condition? Okay. 79. No. What do you want, by the way? You tell. Okay, when do you want? You tell me so that I can. No one could you. Yes. Yes.
The appellant is dead, fellows. Sole appellant.
Sorry.
Sole appellant is dead, fellows. 64.
64. Do you have anything?
We have sent a letter. It is written. Okay.
Sole appellant dead. Because subjects that we have sent a letter to the sole appellant and got a response. The sole appellant has expired on.
Because it's written expired and return to sender.
The total endorsement indicate that the sole appellant has already expired, but therefore the that was written. So there will be some that can be in the absence of any applications.
May I please, Your Lordship?
What is the item number? You said?
64.
May I please, Your Lordship?
1 minute, madam. 1 minute.
Yes, sir.
Yes. No problem. So then don't take a big, longer date. Take a shorter date so that first week number. Okay. First week. Yes, madam.
May I please, Your Lordship? Item number 93 may kindly be taken at 2 p.m. Your Lordship. On behalf
Obviously,
of
it
Mr.
will come
Soras.
after 2. Obviously, it will come after 2 only. Don't worry. Eh?
Yes, Your Lordship.
Okay. Yes. Yes.
Item 1.
Where is that file? Can you give me? Yes, Mr. Acharya, that judgment was reserved. What do you want?
Yes, actually, my lordship,
I just forget it now.
that day I was in online, virtually I was doing, I could not place the money.
Yes.
The case is that there was a charge under section 302, 304B at 498A and section 4 DPI. The London Trial Court has acquitted me from the charges under section 302 and 304
Oh, I understood it.
and reduced
In the absence of any immediate sudden provocation, 306 can't lie.
306, he said the charge is the conviction is reduced to 306.
Hmm.
So now what the other day, what I understood from the argument of my learned friend, that there was a demand of balance 5,000 rupees for 4 to 5 months after the marriage was took place in 1998. Death is 2000. So for 5 months, they were, that is evidence is there, they were living happy. They were living a happy married life. Thereafter, for rest 5,000 rupees, there was a constant demand. For that is maybe suppose in January 98 their marriage, for May up to May they were living happily.
Yeah.
After June, they demand was constantly made. That is the allegation.
Hmm.
After 5 months after their marriage, the demand was constantly made. So what happened? And in the meantime, whenever the family member were coming, they were asking for the rest, and they were assuring that then they will give us some time that they will pay back the money. So just before the occurrence, there was a marriage in the family of the deceased. His cousin was getting married. So they have come to invite the family of the in-laws. And they also want to take their daughter. So the father-in-law is Duryodhana, who is not alive, is dead. He said, no, she will not go today. She will go on the date of marriage.
Yes.
So on the date of marriage, Duryodhana and Chandramani, the other accused, they, along with the deceased, went to the house of the paternal home of the deceased. And Duryodhana, the father-in-law, on the same day came back to his nephew.
Yes.
And
Came back with a
Chandra,
warning, came back with a warning that you pay 5,000
that
along
is,
with a sister.
That's right. That
is there.
that is the evidence of PW
That is not there. that is
PW
evidence.
1, PW 2,
That is
And,
consistent. That why I
PW.
say after 5 months of the marriage, there was a
Now,
consistent.
what exactly you want to see? You want to
Yes. So Duryodhana came back. Chandramani remained for 4 days. That is the evidence of PW5, PW8 also. There,
I know, I have noted down all this.
yes. Chandramani remained for 4 days.
What do you want to add?
Yes, I want to add. Then, after 4 days, Chandramani left. He also gave a warning that you pay the rest of the amount. They said that we are considering. Then, after 8 to 10 days, the uncle of the deceased, Pabani, PWA, came along with the deceased to leave her in the matrimonial home. Then it is alleged that there is evidence that Chandramani and the other sister-in-law, that Jita, Sanju, they said that unless the amount is, we will not allow her, or we will kill her by crossing the stone. Then Duryodhana interfered and she was allowed to stay, and also Pavani allowed to stay in the house on the night. So my humble submission before your lordship, my lord, if there was a strange relationship, my lord, because your lordship knows that in order to attract 306, the ingredients of 107 is also required. So far Dinabandhu is concerned that he was not there. That is also the evidence of one of the PWs.
He's here. He has died. Already died.
Another DW also said that Dinabandhu was working 100 kilometers away from the place of occurrence. And my humble submission before you, that day I should not point it out, that PW1 brother says, 3 occasions I have gone to their house, I was treated properly. And Pabani says, PW5 mother of the deceased and uncle of the deceased, they said that they came and stayed for 4 days in their house. And Pabani says that on the day I left the deceased in the matrimonial home, he also stayed there.
Which part of the evidence you want to show me?
My lord, your lordship may kindly. PW8, your lordship may kindly.
PW8, huh? Come on, let us see that. It's not for PW8. I'm there. Which part you want to show?
My lord, PW8 para 3 it was
Para 3.
para 3.
Read it.
A lady led a happy life in her husband's house for about 5 months. Thereafter, Gedi informed that the accused persons were harassing her as the rest amount was not given as per the demand made by them. After 5 months of the marriage, Gedi returned to her parents' house along with her alone because of the harassment caused by the accused persons. She informed about the demand of harassment during her stay in the parents' house. Accused Duryodhana alone came and asked to give the rest amount. Thereafter, accused Dinabandhu also came and asked to give the rest amount. I left JD in her marital home house and requested the accused person to allow to give the amount later. On one day before the date of marriage of my brother Rabi, went to bring JD, but accused Duryodhana did not allow her to leave the house, stating that he would send her on the date of marriage of Rabi. On the date of marriage, my brother accused date of marriage of my brother, accused Duryodhana Chandramani came with Gedi to our house. Accused Duryodhana left the house, warning us not to detain Gedi and send the rest dowry amount immediately. Accused Chandramani stayed in our house for 4 days. He also gave a warning the same manner as given by the accused Duryodhana. After 20 days of the marriage, of Rabi. I left her in the house of the accused person. Being asked about the rest dowry amount, Jita Jena, I told to give the amount before Raja festival. Accused Chandramani and Manju further threatened telling that they would kill Gedi by means of stone if demand was not fulfilled, and they asked me to take Gedi. While I was returning along with Gedi, accused Duryodhana and his sister-in-law interfered and requested me to leave Gedi and there and not to get another. I stayed in the night and returned on the next day, promising to give the dowry amount before Raja Sankranti.
So what happened there?
My humble submission before your lordship.
Merely because he stayed in that night, then the entire evidence will go.
No, I don't say. My lord, this is the human conduct. Your lordship may kindly see if there is a
It's
strange.
human conduct
No,
because
no.
they requested he.
My lord, what I beg to submit, my lord.
Hmm.
My lord, the demand was not on that particular day. As your lordship the other day said that she felt insulted. That is why she took the extreme step. to commit-
See, the family members are humiliated.
No, no,
They stayed.
No, no.
Allowed to enter to the house.
And so that is the
No,
reason.
my lord, this is not the first time this thing is happening. This is happening since 5 months after the marriage.
Yes.
This is in 2000, in 1998, this thing was happening, has been happening.
Yes. Next,
So-
which evidence?
So
I
that,
understood it. now.
that is that, and they stayed, the father-in-law, brother-in-law, all of them had gone to attend.
I think I have already underlined it. You have pointed out this part.
No, I have not
That
pointed.
has been already pointed
That
out.
part I have not pointed
Underlined.
out.
Anyway, but now you.
So,
Yes.
my because this is your lordship, if there is a strange relationship, if I am not comfortable.
So see,
No, no.
these kind of relationship are so
No, matter. The point which I am bringing to your lordship kind notice that my lordship kindly see the demand. If the demand would have been on the same day or the first time it was made, yes, that is understandable that she felt humiliated for the. But this is according to the prosecution, this is a consistent
Continuous.
demand from 2000 from 1998.
after the fifth
5 months after.
5
the
months
marriage.
after the marriage.
So if this is thing was going on, she could not have committed
What
suicide.
you want to say that where is the sudden
What
provocation?
is the sudden thing
Sudden-
happened? What is the sudden abatement? What is
But
the evidence?
sudden what she says is because of the marriage of the Rabi,
Huh.
all of them came,
Yes.
and that day the relative of Gedi was so misbehaved,
No, not
continuing
not-
no, that's what the evidence she said pointed out.
Let me finish.
So that may be the triggering point
Much-
for which she might have committed the suicide. That's what her case is.
that is what she said. But my humble submission is that this cannot be because if had this incident occurred for the first time on the same day, yes, it is understandable that she would have been insulted. And again, another thing which your lordship may kindly see that I was also thinking that there was some injuries, antemortem injuries are there on the body of the deceased. That might be a reason that she was assaulted or for which she might have been could not sustain the physical assault and for which she could have put an end to her life. My lord, your lordship may come to the evidence of DW1.
Can you see the PM report as well as the Panchnama?
No. There is
Let-
an antemortem
These
injury.
are to be
1
seen.
minute, madam. Let him complete. We'll see.
Injury.
DW?
There are certain
Okay, it's all right. You come.
antemortem injury on our body.
Show me DW.
Your lordship may kindly see DW1.
Yes.
Akshay Kumar Jena.
Yes.
And as your lordships know, DW and PWs can be treated equal.
Hmm.
That is what the law says.
Yes.
So if he is a defense witness, he cannot be treated differently. So I know, your lordship got it?
Yes.
I know all the accused persons who are of my village, and I am residing on one house away from from my house. I know the deceased Prabhati, wife of accused Dinabandhu. She died by hanging in a rope. On hearing the shout of Sanju, sister of the accused Dinabandhu, from their house, when I went there, noticed the deceased was being hanged by a rope. As such, I caught the rope by means of a sickle. As a result, the deceased fell down on the left side.
Yes.
At that time, deceased was alive,
Hmm.
for which I gave her water. Thereafter, some villagers and the accused persons except Dinabandhu who were harvesting paddy from the nearby field came to the spot. 10 minutes thereafter, the deceased brother had lost. Hence, the matter was informed to the Mangalpur police station and the parents of the deceased. In the same day, night, police came to the spot, interrogated me about the matter. On the following day, around 9 or 9:30 p.m., around 50 to 60 persons from the parents' village of the deceased came to the spot. After abusing us, ousted from the place. The dead body of the deceased was taken to Jajpur for PM examination. I accompanied the dead body for the deceased to Jajpur, but at the Jajpur, one Pabani, uncle of the deceased, told the doctor of the Jajpur to report the case is a murder case. The doctor, these are not very important.
DW1, huh? This is-
DW1. Then SCV, then his cross-examination, my lord, may kindly see. This is Prabhati married, cross-examination by the prosecution. This is married, Prabhati married to accused Dinabandhu 7 to 8 years back. My village, Sananda Jana informed the incident at Mangalpur PS. So also Sananda Jana informed the incident in the parents' house of the deceased on the same day. At first, police Mangalpur PS came to the spot. Thereafter, people.
Okay, I got it, I got it.
Yes.
But 300,
Here, my lord, what I beg to submit, my lord, there is absolutely no suggestion by the prosecution that this is was
What is
he
your stand in
got the rope.
what
he
is your
fell down.
stand in 313? Where have you said that? Let us see 313.
Can you please help me?
917.
Huh?
That's there already.
Okay. No, no. Dinabandhu and Sanju.
Publicly mature କଥା mature.
No, देखियो what questions has been transfer from the evidence of PW1 Dhirendra, PW2 Chittaranjan, PW5 Sarathi, PW6 Saponi, PW7 Goloka, PW8 Pavani, PW9 Sibo that you married to Prabhati Gedi and 98. What
In the 313 you have not said. Only so.
313 the first question up to Dinabandhu I am just placing.
No, I have seen it 313. Complete.
Yeah.
And what else you want to add?
So
Yes. What else?
whether that particular evidence has been,
I got it, I got it. I have
there is
seen it.
nothing about the,
I have seen you have said Michakotha, that's all.
yes.
Everywhere. What do you want to add?
As your lordship, on the day the deceased was left in the house and she was humiliated, no such question has been asked. Your lordship may kindly see.
I have seen it, everything.
That is not there.
Anything else you want to add?
So that is the
Right.
point, and evidence of Dr. Your lordship may kindly see
I've-
that there are two antemortem injury, which has been explained by the defense witness that while cutting the rope, the deceased was lived and fell down.
Kindly see.
And doctor has also accepted the suggestion that this injury can also be possible by fall.
Yes, sir.
So, my lord, my humble submission is that Dinabandhu was not, there is no specific allegation because Dinabandhu was out of, was not at the home. He was 100 kilometers away from
He
his.
was
at
in the
his-
paddy field, you just read.
No. Who
just
said that?
read the DW1. Sir, you
No,
just
he
read-
was not. Rest of the accused. Please, ma'am, please kindly see. Rest of the accused, except Dinabandhu. Except Dinabandhu, rest of the accused were in the paddy field. They came.
Question number 30.
As such, I caught the rope and at the time deceased was given some water. Thereafter, villagers and accused persons, except accused Dinabandhu, who were harvesting paddy field nearby, paddy from the nearby field, came to the except Dinabandhu.
I'm-
Dinabandhu was not there, and even I'm just taking your lordship to PW7. PW7, their prosecution witness, and he has not been declared hostile. PW7, your lordship may kindly see.
What has he said in 313 Dinabandhu?
Sir, can you see?
Dinabandhu was absent.
It was just stated that no specific question was put on the regarding the occurrence on the
Yes.
happened that day. Can you see
Question
question
number?
number 13?
1 minute.
It was put to Dinavan only.
Dinabandhu, no?
Question number 30.
Then yes.
It transpires in the
Question
evidence
number?
that 13 inch.
One, yes.
It
transpires that to the evidence.
After marriage of robbery, it went to leave Gedi in your house, but you along with the other accused person refused to accept her stating that the demand was not fulfilled. What do you say, Mitchell?
My lord, there is no evidence that Dinabandhu was present and asking for dowry. My lord, what is the relevancy of asking such a question?
You just said
No,
that is not.
I want to say, if this question has been formulated basing on no evidence, then how this question is relevant? The evidence of PW5, PW2 and PW8, there is nothing that Dinabandhu was present and asked and did not allow the Gedi to enter into the house.
What PW8 says?
PW8 says that Chandramani, Sanju.
Let us see PW8.
PW8, your lordship.
Dinabandhu, where is it?
PW8, your lordship, may kindly see. So this is an irrelevant question. PW8, accused, your lordship, may kindly see paragraph 3 towards last. Your lordship got it?
My question.
Para two was.
No. Presence of the accused.
Presence of the accused is necessary for 3.
No. That is not there.
No,
Your lordship may kindly see. Your lordship got it? PW8 para towards last para 3 accused word start with accused Chandramani. Got it?
Yes.
Accused Chandramani and Manju further threatened me, telling that they would kill Gedi by means of stone. Demand were not fulfilled. Where is the Dinabandhu about Dinabandhu? There is nothing. That question which my learned friend is saying, that is absolutely irrelevant question has been put.
It's not relevant.
It's not. Why you are saying irrelevant
Because you
question?
said that is not put.
No, that is not. The
One minute.
irrelevant question is no question.
There is no point arguing. Both of you are.
No. I'm not arguing. My learned friend is showing a
Let
question.
us go in a.
If that is not brought out from the evidence.
Your case is Dinabandhu was
Dinabandhu was
not
absent.
there.
Dinabandhu was absent.
When
And my another thing is that Chandramani, if they are a strange relationship, can anybody will stay?
let us concentrate on Dinabandhu.
Yes.
Dinabandhu. Yes, madam. Dinabandhu. Presence of Dinabandhu.
Assuming Dinabandhu was not present. Assuming.
No, see, for 306,
Yes.
immediate and sudden provocation is required. If he is absent, then there is a story different.
What my limited understanding.
498 is there because in the first paragraph, see, in para, if you see in the para 2 of PW1, and he has specifically said, accused Dinabandhu on the same so and so, he was there in the house.
Yes,
And
that is there.
he was demanded, dowry demand is there. There is no doubt. But what he's trying to say is, insofar as Dinabandhu is concerned, on that day he may not was
There. But for 306.
sudden provocation or immediate.
How, my lord, how 107 has been made out? Let my learned friend.
For 306, that need not be any sudden provocation. So may I kindly see.
No, sudden provocation it is not the case of sudden provocation. You must fulfill the criteria of 107.
Understand. See,
I'll just.
see, demand of dowry was made at the time of marriage. Thereafter, see
Instant demand.
how the story goes.
Yes.
After the marriage, 5 months, everything was okay, no problem. After 5 months,
5 months, first time the deceased informed a parent that I have been tortured. Torture was there.
torture,
5 months they were
continuous torture is
for
there.
5 months they were living happily.
That's what the evidence is.
Didn't know about it.
After
After 4
we
months.
presume that the 5 months they were tortured.
Anyway, yes.
After 4 months, at the first time the deceased informed our parents and siblings and some other independent.
Dinabandhu is the brother-in-law,
Yes.
Dinabandhu is the husband.
husband.
I just placed that particular judgment which I was placing on the other day. Is that the proof of direct or indirect act on the part of the deceased.
That judgment I have already read. And he wanted whatever he want to add on that only the hearing. I can't hear the appeal once again. I've heard it already.
107, there has to be instigation, abatement or aiding. So in this case, there was instigation was there. That instigation which the circumstances we go to instigation, there is a constant demand of dowry by all the accused persons since the date of marriage. Thereafter, one day she left the matrimonial house because she could not bear the torture. Then again, Dinabandhu and Duryodhana took her back to the matrimonial house. Thereafter, the demand was there. Thereafter, because of one marriage in the family of the deceased, she was brought to the her parents' house. And while returning, also the other accused person, Duryodhana and Chandramani, they made a demand.
No, not Durjana Chandra.
Duryodhana and Chandramani, they made
Chandramani and Sanju.
Lordship, while leaving the deceased at her house, the Duryodhana and Chandramani, they both raised a demand. And while dropping the deceased by PW8 at the house, the mother-in-law and the sister-in-law again said that unless the demand is fulfilled, we will let her enter
Yes.
into the house. And in case, we will kill her. And the other
Right.
day, she was found dead.
Okay, right. The
I'll
matter
give
was
it, My
heard.
lord,
Matter was heard on 18/9/2025, and the judgment was reserved. Mr. Arun Kumar Acharya, learned counsel for the appellants, subsequently made a mention before this court for further argument and requested the court to release the matter once again. Accordingly, the matter has been listed today as a to be mentioned category, and the matter is again heard at length, and judgment is reserved.
I'll file a note within
And
by Friday.
Mr. Arun Kumar Acharya seeks to file a additional note of submission, which is permitted. Let him do so within a
Friday,
week.
by Friday.
Because partly
Yes, yes, yes. Friday.
then I forget, then again I read, and
I assure
you want to, madam, you want to file anything?
I'll file.
by Friday I will.
Liberty is
file
also
for
granted
stay.
to the state council to file an additional.
Friday,
request,
latest
written-
I will.
Thank you. Thank you. And whatever you want to,
Because one thing.
yeah, I'll just in written
Then-
note, the evidence of any witnesses, you please reproduce, so that will be easier.
Will highlighted those.
Highlight and reproduce those things.
And main thing, my lord, your lords, I request your lordship to keep in mind the natural.
How much you have undergone, by the way, three of you?
Maybe 3-4 months, like,
Not much.
not much.
So, there is minimum sentence, that's the problem.
No, initially since it was a 302, for some time they were in custody.
Oh, that's what.
The in-laws
Can you
were-
give me the
No,
custody period
in-laws
also?
Released, but the husband remained for some days. Exact.
Please find out. Tell me that from the record if you can.
Oh, it is not there.
Fine, just see the final form when they got the bail and the proceedings and all.
It
This
is not-
exercise has
it
to
is
be-
not here.
It is there, trial court record.
No, it has not come.
To be
We mentioned.
Ticket ଯଦି କାଲି
You
ଟିକେ
can,
ନେଇ-
why don't you send your junior to go and see in the registry
Yes, yes,
inspection?
I will find.
That you do. These are the junior's job
Yes,
basically. Let them do it. If you can't find it out, tell me so that I'll call for the record. Okay. Okay, yes. To,
Time, but I'm saying that not very, maximum 3 to 4 months.
because 302 was there, therefore I'm just wondering whether,
At least 7 months, I think, chassis, but others were.
let us understand if sentencing part, yes. Yes.
Item 2.
That is that, my lord, after a long sending a person. that
See,
is-
these matters are pending
That is.
from the 90s.
Or it is nobody's fault, neither we can blame the court nor we can blame us, but that is how these things.
Better is to blame each other.
But yesterday one matter was before Justice Mahapatra, Justice A.K. Mahapatra court, and his lordship said in 2001, leave to appeal has not been listed. There are, what is to be done.
But whatever is there, let us try to finish it up.
Yes.
Otherwise, it is burden on the court. Okay. Yes.
But
Two, yes.
both the appellants have died.
Right.
Some
Right.
medical
Uh,
appellants.
Abatement, huh? Abated. Yes. Both the appellant died. The reports is taken on record. Yes, next.
Item 3.
Three, Konala.
In the connected appeal CRA 24 of 1996, the appellant is alive.
Sorry.
Appellant is alive.
Appellant is
Lordship, my pardon, Lordship. In item number 3, The appellants are
There
not.
are two appellants, huh? There are two appellants,
They're not found there. They have left the.
not trust out.
Yes, sir.
What is this? Age 85,
Yes. Sir.
and another is 55. Who is appearing? Nobody is appearing.
It's get required.
कौन है advocate है बोलो? Nobody is appearing. Who is PK Mishra? Yes. The problem is nobody is appearing, and one of them is 85. Huh? The Wakalatnama which I found,
Must have elevated.
one of them has been elevated and retired also. The other other counsel is a sitting judge now. What to do?
For that reason, only the name has been. Deleted.
What is the offense? See, madam, what is the offense?
Yes, sir. The charge understood 448, 323, 336, 147.
Offense, sentence,
Sentence, sir.
single blow.
Yes, sir. 304 part 1.
So, the pursuant to the order dated 9/9/2025, the report is placed on record. As per report, the whereabouts of the petitioners are appellants are not known. From the record found that
He may be part.
found
Bishop,
that
324, 330.
presently the appellant number 1 is 85 years of age, whereas the appellant number 2 is about 55 years. 55 years? 55 years. The counsels, those who were appearing before for the appellants, have already been elevated as is judges at this court. Therefore, there is no representation in that view of the matter. So I'm showing appointed as a case. Yeah, this matter. Yes. Yes.
Item 4.
Item number 4, in the connected office, CRA 24 of 1996, the appellant is alive.
24 died.
No,
Alive.
appellant is alive.
What about first one?
The first one, they're sending the declaration, kindly pass. The first appeal, CRA 10 of
10.
96. There are 7 to 8 appellants.
You want time, huh?
So,
In
day end.
in criminal appeal 24 of 1996,
The appellant is
the
alive.
report has come, which is placed on record alive. Insofar as criminal appeal 10 of 96 is concerned, Shivulakshmi seeks further time to get the report. Please the matter on source. Yes.
1 week.
1 week.
5 and 6.
1 or 2 weeks or 1 week?
Pardon, Your Worship.
1 week.
I'll go
Little
to
more,
the end.
little more than 1 week.
Next.
Because these are 96 matter.
Yes.
What are the offenses?
304 part 1, convicted in 304
Yes.
part 1.
Okay. Next. Yes.
Item 5.
5 and 6. You see, I may be favored with a paper book, Your Worship. The file is not there. That's why I could not.
Take the paper book,
Yes.
soft copy.
Sir.
You got the report?
No, Your Worship, I could not write.
Okay, 5 and 6, further time is granted to, further 1 week time is granted to obtain the report, and the state council is permitted to obtain the soft copy of the paper book. Yes.
7.
Take it today itself, huh?
Yes, sir.
Yes. 7.
7 Your Worship, and this.
Hmm?
This is forwarding the report.
Got the report? Yes. Yes.
Along with the death certificate, there are multiple,
There is many of them.
many of them.
Many of them.
2 of them have died. Have
Oh.
given the death
Give the
certificate.
report, we'll pass the order. Okay. Report, pursuant to the order dated 24/7/2025. The report has been placed on record according to this order. Yes. Yes.
Item 8.
Madam, get ready. Get ready in this matter. Okay. See, this is 97 matter. Okay, appearance. Okay. 8.
Item 8.
Can I pray for next week?
Next week. Okay, next week. Yes.
Item 9.
Who's alive, your lordship? Because some more, by day and I'll provide the report. He's alive. The appellant is
Alive. Huh?
My lord, item 9, I am appearing on behalf of the appellant, my lord. He is alive, my lord. So far offences are concerned, minor offences, your lordship kindly consider today, I will conclude, my lord.
Okay.
That is offences, my lord, that is he is acquitted of offence 3 SC/ST Act, my lord.
Huh?
And he convicted under section 448, 354 and
What is this? What is the
509.
sentence? What is the sentence?
Sentence maximum is 2 months, my lord. Out of that, he has already in custody probably 15 days, my lord. As I have verified just now, 5/8/1995, he was arrested and produced on 6/8/95. Released on bail bond shows 23/8/95.
Imprisonment 2 months. 2 months.
2 months.
For 448.
448.
2 months for 354. And
and
simple imprisonment for 1 month
for
of
509.
so run concurrently. Yes, madam. 2 months sentence
as of
already undergone.
No, my lord. 5/8/95.
15 days you have already
My
undergone.
lord.
It's already
Yes,
undergone.
obliged.
yes.
ठीक है conviction maintain and counsel for the petitioner appellant submits that the appellant has already undergone 15 days. 15 days. He confines the appeal to be limited to the question of sentence, conviction maintained, and period converted to already undergone. ठीक है करके इसको खत्म कर दे ठीक है okay disposal. Yes.
Item 10.
From 10, I request a motion.
You need time?
Yes.
1 week. Yes. 11?
11.
Yes. Let us see the report. Yes. 11 and 12. 1 week. Huh? 11 and 12. 1 week. Why have you gone slow down now? Report used to come little faster. Now slow down. You need some energy, it seems. Okay, 1 week. Yes. But I think most of the matter we got the report. There are couple of matters only. 26 matter is listed today.
Yes.
I think we have achieved the object. Yes, next.
13.
Alive. Got the report. Take it. Huh? Like 98. Victory. Yes. What is the offense?
That's 3/1/11 of SC/ST Act.
Mr. Mahandi, just since you are there in your case, already undergone period, find it out.
Yes, sir.
So that next time it will be here for you. Yes. 13. Okay, we'll hear it. Huh? 13 report has come. Huh? Give the report. 14.
No instructions.
Hmm?
14, 15 instruction.
Not received. 1 week. Huh? 14, 15 and
16.
16. 1 week. Yes.
17.
17. 11.
Alive. 17 report has come. Huh? 18.
18. Yes, that is why we got this.
You have not got it. Simply say.
Yes, but here it is. What is from from
What is the report? Is alive or died?
I dare to report that only one which comes under Kaliapani is.
Okay, for the time. Okay. 18 for the time. Okay. Next.
19.
19. Received. No person could be placed in that case number.
No person. How many of them are there? One. Kirasakar Rao, Raju.
K. Rajeshwar Rao, Your Lordship.
Yes. Military lane, Parampur. You didn't get.
Could not found any person. During inquiry, nobody in the locality could able to say his whereabouts.
Okay. What is your instruction?
Your Lordship, we also have no report. But if your Lordship keeps it after lunch, I'll argue the matter.
What is the offense?
Your Lordship, the offense is under 425. Pardon, 452, 325, 506, and 34.
What is sentence? Sentence about
1 year.
1 year. 99 he was 35. That means now um, 60. Get ready. then.
Oh, yeah.
Get ready.
Obliged.
Civil get ready. Yeah, pass out. Okay. Yes, next.
20.
20 I will see no suffering.
Instruction नहीं हाँ ठीक है 21
One.
will pass you 21 yes 1 week okay 1 week 21 1 week 22
22 is alive, your lordship.
alive
Yes.
report is there
Sanjay were expired and the Amruta were alive.
अच्छा ये report ना 22 23
23, 1 to
24 25 25 25 तक है ये report हाँ 25
26 with
26 where is 26 26 you have
Lordship, item 20.
20.
Item 24. Appellant has filed one fresh wakalatnama without consent. Maybe the victim.
24 you file वकालतनामा
Yes, yes, Lordship.
if he is alive ठीक है
26 died.
26 का ही
26 died, your lordship.
died
Okay.
26 कर दो died हाँ 26 and 27
Outside time hearing.
hearing aussi and what is 29 then
29 they would not as a non-pressed.
Extra hearing.
29 लिखा जी तो order
Extra
where about not no छोड़ो
इसे
इधर आ जाओ ठीक है चलो let us come for hearing 27
27.
27 बाकी चलो देखियो 28
28.
29
29.
nobody is there
Obviously.
yes
30.
anybody is there
30, item 30, your lordship, I'm on VC.
yes
I'm praying, your lordship, if it can come after Diwali, let a
no
date
no
be
no Diwali these I have categorized this matter only these are the small matters for essential commodity check
Yes,
I have
your lordship,
categorized these matters you
your
argue
lordship had directed to file a
date of
written note
acquittal,
of sub-
it will be acquitted. Otherwise, probation of offender check.
No, actually, your lordship, what has
And
happened
both the
today,
cases is a win-win situation.
I'm ready to argue, your lordship, but the only thing is I am in a difficult position today.
Day after tomorrow, I can put it.
Yes, your lordship, day after
Day
tomorrow,
after
I'll.
tomorrow. Yeah.
All right.
Yeah.
Obliged, lordship.
Because see, there are how many matters are there total
Total 90.
in a ECA?
Lordship, tomorrow also I can argue, no problem. It's just today I'm in a difficult position. Tomorrow also I'm ready.
Today afternoon, if you can argue, I can accommodate you. 3 o'clock.
Actually, Lordship, I have to take my daughter
Okay,
to the
day after,
doctor.
day after.
Yes.
Because tomorrow is a different bench always. Yes.
Yes. Obliged.
Total कितना ECA? See, 8 matters are left in ECA.
I'm ready, your lordship. It's just that today my position is a little difficult. I'm
Okay,
ready
day
to
after.
argue.
Okay, no
Obliged.
problem. Yes,
Obliged.
next.
31.
31, your lordship, there are two appellants. There is noting is that appellant number 1 has already been expired. So for appellant number 2 is concerned, the appeal is pending for hearing, your lordship. And
Appellant-
certain EC act, your
Sir,
lordship.
1 minute. If there are 2 appellants.
Out of 2, there is noting is that appellant number 1 has already been expired, your lordship.
Expired. 2 is there. Okay. 2 is there. What is the sentence?
7 EC act, your lordship, conviction 6 months, your lordship.
6 months.
Lord.
Call Mr. Ponda. Call Mr. Ponda. Tell Mr. Ponda. ठीक है? Password करो Ponda. Mr. Ponda, this is 31. Ponda. Yes.
32.
Please, your lordship.
32.
Yes, your lordship.
Yes.
Convicted under EC Act, Section 7, 1 year imprisonment.
There are two
Two appellants, your lordship.
File nikalo. Let us proceed. Huh? Yes. Yes, madam.
Your lordship, conviction under Section 7 EC Act, sentence for 1 year imprisonment plus 5,000 fine.
How much you undergone? Just you keep on finding out. Huh? I'm hearing. Undergone period, just find it out. Please, later.
Your lordship, a rate
This
was-
is state council has to assist also. State council has at least undergone period will tell. Yes.
Your lordship, this appellant 1 and 2, appellant is one is the proprietor of the mill and 2 was there in the mill. During raid, 1 was not present, but he was the proprietor and 2 was present.
Proprietor. One is proprietor. Huh?
Proprietor, your lordship.
And two is
2 was working in that.
He's employee.
Yes, employee. And in your lordship, the allegation is the storage was of heavy quantity and they were operating without license.
What is the store? What you have told?
The stock which was there, it was of the heavy quantity. And then when they asked for the license, then no license was there. The plea taken by them that they have applied for license, but
Yes.
they have not yet received the license. That was the plea. I've taken the ground, your lordship, in page 6,
Nine.
para F.
Is 6.
Para F,
Para F.
your lordship.
Yes.
For that, since the application for grant of license, neither having rejected nor any differ have been pointed
out.
out.
No,
No
prosecution could have been.
have
Achha, you have applied.
I have applied.
When have you applied? Date tell me.
The date which we have applied
Huh.
is in the raid was in 90, we applied in 89.
89.
Yes,
Applied for license. In the year
89.
1989.
That is there in the judgment also.
Let us see. So
Judgment 5, page 5
page 5 of the
of the
judgment.
judgment.
Page
Paper book 12, page 12.
12.
Para 6, your lordship.
Show me that. Yes.
The learned counsel for the accused person, while admitting the seize of stock from the prosecution of the accused person, submit that the accused person had already made an application for license to the property authority, that sub-collector, before the alleged date of seizure. But the matter was delayed in the civil supply office, and accordingly the defense has examined one witness, one of the clerk of civil supply office, who producing a letter that is in exhibit B, it is there.
I have a judgment on this subject. Do you have that judgment with you? I have acquitted on this ground.
I'll see the judgment. I have another judgment to it.
You have the judgment,
Yes,
give.
I have a judgment.
On this ground, I have acquitted.
Yes,
And you very well, you have examined a clerk of the.
yes, that is in the
That's
defendant number
that is a DW,
DW1. That is the only
and
difference.
you have produced the letter also, exhibit B.
Exhibit B.
What else you? Yes. DW one, no?
DW1.
Where
The
is
only
that?
difference. Should I read it, your lordship?
DW1 is 9. In 313, have you said that? Have you said?
Page
313
31.
statement, Karachi. Yes.
Page 31 is mentioned.
Have you said that you have applied for it?
Yes.
No, Hal is saying no, no, no.
1 minute. 32, na? Item 32.
32. I'll give my written note also. I prepared.
The question number 6. We had applied for the license, but it is not available. DW1, na? DW?
Yes.
One.
The only one.
Clerk of Civil Supply.
Civil supply.
Exhibit?
B.
Exhibit B.
B.
Yes. Show me this judgment. Show me the judgment. Yes. Which paragraph? Madam?
11 and 12.
Para 11 and 12. 11 and 12. Yes.
At the previous time, it stored students considerably in excess of 100 grams and had no license to carry on the business as a dealer under the license order. His defense at the trial for contravention of section 3 of the order was that he had applied for the license and had deposited the requisite fees for obtaining a license and had submitted an application in that behalf, and since that date continued to submit fortnightly returns to receipt and sales of equipment regularly. He also submitted that he has made effort for 2 months to get the license, and the inspector had assured him from the time to time that he therefore need not worry, and the license would be sent to him at his residence. This
Yes.
directly amounts to an collect knowingly carried out business as a dealer without a license.
Got it. Eh? Do you want to say anything?
Lots of,
License applied, not issued, pending, in between, raid has taken place.
but,
It is the duty of the civil supply officer to process the application and issue within stipulated time. If it is not issued, despite the fact that it is applied, sufficient material has come on record to suggest that she has applied for the license, which has not been issued by the competent authority. In between, the raid has taken place. Even she has admitted that the raid has taken place, sufficient recovery is there, and the only offense is not having a valid license.
valid license.
License was applied for. So therefore, she is entitled to an acquittal. Acquittal. But I have a judgment on this. Find out. A written note is not required, but if you can find out the judgment by evening, give it so that half of the labor will go. Okay. Find out, huh? Huh? Give it. Why have you kept it? I don't know. I think there is a provision also. I have quoted that provision. I don't recall. I have quoted that provision saying that, see, within this time the license has to be given, or otherwise deemed approval kind of thing. Something of that sort I have written. Anyway, let's see. I'll also find out. You just find out. Thanks, Rocky. Thank you. Yes. Yes.
33.
33.
Please, Your Lordship.
Yes, madam.
The appellant is convicted under section 7 of the Essential Commodities Act for contravention of the
Really?
8 of the Orissa Rice and Paddy Control Order 1965.
Yes, bigger matter. Mr. Raghuda, there is a 304 part 2 matter. The lawyers, those who were appearing, one of them was become judge and retired, and the other lawyer He's a sitting judge now. So help the judges. Because it's a little heavy matter. So I need a senior should do. Sir को भी sir का नाम ये रखना देना. नहीं 3 तो रगड़ा हो गया ना. आगे कुछ दे दो. Question he is ठीक है. Yes. Yes, madam.
The appellant,
Give the paper book photocopy and Mr. Ragada. Yes.
and the appellant is convicted under Section 7 of the Essential Commodities Act for the conviction of the offense, Clause 8 of the Orissa Rice and Paddy Control Order 1965. And sentencing undergo arrive for 6 months and pay fine of rupees 500. So the appellant is was the secretary of the Gram Panchayat office, and the conviction is by a special judge come additional session judge Rairampur. That conviction
Who was Basudev Murmu?
Basudev Murmu was the peon of the Krutidas.
He died and
Yes, he
elevated.
died.
And now you are from Kutivasgiri.
Yes.
Kutivasgiri, 59 he was.
Yes,
Hey.
and now Krutibasgiri age is 85 years old.
Only. Yes. Yes. What are the allegations? What are the evidence?
Allegation, the Basudev Murmu was detained by the villagers, and the allegation against him is Krutibas Giri was directed the Basudev Murmu for taking rice of 45 kg from Gram Panchayat office to the place of the Krutidas Giri.
BPL rice.
Yes, BPL rice. which
BPL
is-
rice from the office of the Gram Panchayat.
Yes.
So and so, and the rice was selling for 2
Yes.
rupees per kg.
After
The
detained
instance of the secretary accused Vasudev Murmu was going away by taking 42 to 45 kg
5 kg.
of rice from GP. At the time, the occurrence of informant was the other solution made the entry, and the villagers informed.
Yes.
Seeing the illegal transportation, the accused Vasudev Murmu, the informant and other obstructed him and kept the illegal so by so morning informant. Now come to the evidence. Then it was recovered from Basudev.
Yes.
And
the
how you are linked?
After extrajudicial confession, Your Lordship, if Basudev Murmu said that the direction of the
He is co-accused.
Yes, is co-accused because of
What
the
else is there?
statement. The Krutidas Giri was convicted.
What is the evidence then? Co-accused evidence except
Only-
co-accused. What
except
else is there?
Only the co-accused evidence is there, statement is there, and thereafter nothing for the Krutidas Giri.
Let's see now.
And 131 statement of the Krutidas Giri is that the informant, because of previous enmity, the informant has falsely implicated in this case, Your Lord.
Okay. 8 witnesses were examined.
Yes, 8 witnesses I examined, including the IO, Your Lord.
Who is PW1? Villager.
Yes.
Huh? Informant.
Yes, informant. PW2 is the villagers.
Villager.
Yes. PW4 is the son of the Krutidas.
Let us
Giri.
read informant. So he says that on confrontation, he says that it is the Krutibas who is directed. Huh?
Yes.
On query, he again say PW2 also says the same thing.
Date of occurrence, your lordship, 14/8/1997.
What is the quantity?
Quantity is 40,
Quantity of rice?
is 40 kg.
Huh? 40 kg.
Yes.
Come to PW8. Come to PW. What is the quantity he says? Para 2.
Actually, the accused, there also PW2 is clearly stated that.
Read it, don't.
I see the, I arrested accused Pastor Murmu on 1997. I seized 3 quintals 17 kg and
3 quintals 17 kg and 250 grams of controlled rice. And where from you got 40 and 45?
That measurement was not made also, but the fact.
Then?
Measurement not made.
Then? What else you have?
Before you also am placing statement PW2
What is the evidence against this man? See, the story goes like this. The peon Vasudev was carrying some rice. How much? He was carrying no evidence. Somebody says 40, somebody says 3 quintals, somebody says something else. And he was apprehended. He was asked how you are taking this rice. He said that Secretary Krutibas directed me to take it. Okay, this is co-accused confession. Except that, what evidence you have against Krutibas? Basudev, the person from whom the rice was seized, has died. He died, that is, appeal is abated. Now we are concentrating in Krutibas, the secretary. And very surprisingly, just see PW4. PW4 is the son of Krutibas.
Yes.
The key of the Panchayat office and Godan was called for through his son by the sub-collector. What kind of evidence is this?
Who is guarding the society offices clearly stated. Why the present?
Who has said? Who has said? Society? What? Who is he? Who is he? See, PW. Read PW2. What has he said? Para 2, read it.
Your Panchayat was carrying right from the Panchayat office. We detained him and on
our query.
And on whose direction he was carrying that rice. He told that accused secretary.
This is the evidence for conviction. Co-accused was asked by a witness how you are taking this rice. He says that on the direction of XYZ. Secretary, I was taking. Then the secretary is an accused. Where is the evidence? Independent evidence. Co-accused confession in front of someone is enough.
The number 2 for expired person is working is a peon. And the present number 1 is working is
I think I have read it. Anything you want to add, you tell me. There is nothing. Nothing. No. Yes. Thank you, madam. If you want to give a written note, you can give it. Okay. If you want to give written note, you can give. Argument.
I have an appointment MSK series in this case.
Sorry, madam.
I have an appointment MSK series in this case.
I'm not able to follow.
I have appointed MSK series in this case.
MSK query.
Yes.
Okay.
And my name, my spelling of my name is
Okay.
wrong.
Give the name in writing. Thank you for assistance. Write down that name and same paragraph. Thank you, madam. Yes.
Pardon. In item number 32, the lordship has referred to your lordship's judgment regarding that once application has been made under section, have given the details of that.
Oh, thank you. To me, oh, she very she was there. She tell her.
Recent judgment.
No, she's giving the judgment. You agree?
Give the details of the judgment.
Okay, take out the printout. Take out the printout and give it. Maybe 5-6 pages. Give that immediately. Okay. Yes. Thank you. Thank you. Yes. Yes.
34.
What is this matter, madam?
This is a case under Orissa rice and paddy control order.
The same thing which they argued. The same way you argue, why don't you argue it? Read it, argue at 2 o'clock. I'll help you out. Don't worry. You argue it. Only just see what are the evidence. There are how many witnesses are there? Let us see how many witnesses.
16.
There are 2 accused, huh? 2
Yes.
appeals, huh? Let us see how many. Only 16 witnesses, maybe many of them must be formal witnesses.
Yes, ma'am.
Go through it, come at 2 o'clock, let us see. If you can't do it, and day after tomorrow I'll read it. Yes.
Okay.
If you don't have the file, then you can read it from court. Yes. Next.
35.
35.
35, may I please, Your Lordship?
Yes, madam.
Your Lordship, on the earlier occasion when Your Lordship had heard the matter, submitted majorly 2 points.
Sorry.
Majorly 2 points in my defense, madam. First one is that the IO in this case is the informant himself. PW9, he is the informant as well as the investigating officer, my lord. My lord
Yeah.
had asked me to find judgments regarding the same. However, there are judgments relating to NDPS. Regarding to
What is recovered?
recovered, my lord, 155 liters of kerosene is missing, my lord. That the allegation is that he has sold the same to in black.
Kerosene oil.
Yes,
Okay.
kerosene oil has been sold in black, my lord. That is the
Yes.
allegation. First, my lord, is that the
In
investigating officer.
the year 1996, he was 54 years.
Ma'am,
Now he must be in his 70s. Yes.
the investigating officer, he presented a report first on dated 26/2/1996. There was a raid. Before that, he presented a report, and on that same report, he was asked to investigate the matter. There are total 9 PWs, my lord. PW9 is the IO. The rest, out of the rest 8 PWs, only PW number 6 is the one who was working in the shop, my lord. He was an assistant of the accused person, and he has turned hostile. Other than that, all of the prosecution witnesses are officials, my lord. They're the government officials.
PW6 is independent. Lakshman Das.
PW6 independent, my lord, yes, and he has turned hostile. Other than that, there are no.
PW6 is hostile, huh?
PW6 is hostile.
Okay. All are official witnesses.
All the other witnesses are not independent, my lord.
What was your defense plea?
The defense plea, my lord, was first that the IO is the informant himself. The second that the allegation of storing 860 liters in a separate premise, which was called the residential premises, our residential and business premises are both under one Sabik Khata, my lord. Sabik Khata number 113. That has not been recovered. Nowhere has the revenue records been recovered for as to where, in which Sabik Khata the residential premises is situated and the business premises is situated. Both of them.
Your case is the recovery taking place from a place
My lord,
that not belongs to you.
No, it belongs to me, my lord. They are alleging that it does not belong to my business premises.
Okay.
However, we are saying that it is a business premises as because it is situated under one Sabik Khata, 113.
Okay.
However, no such revenue records have been seized.
Yes.
My lord, that apart, the measuring units that has been used, the measuring units of 5 liters has been sourced from a filling station nearby.
Okay.
The authorities of the measuring unit of Puri zone, they did not bring their own measuring units. They brought a 5-liter measuring unit from a nearby filling station. That also has not been seized, madam. Again, PW8 and PW7, both of whom are official witnesses, their statements are first time before court, madam.
Yes.
They have not been examined before by the IO. Lord, even if the others have been examined, there is one predicament, my lord. If the informant is himself the investigating officer, the statement that he has taken on before they have been examined in court, that
You have many points to argue. Why don't you structure it one after another by reading the evidence? You show me. the first point which you have raised is the recovery from the place. Place of recovery is doubtful.
No,
Because there are one from one tanker, something is recovered, from the premises, something is recovered. What are the evidence to that effect? And then quantity. On the quantity also you should focus.
my lord, the quantity, they're saying that 155 liters.
Who is saying? Which they means who?
The IO, my lord, if I go by the IO statement,
Uh,
150.
Read that part of the evidence. Read that part of the evidence. And show me. IO is PW?
9.
9. Let us see what IO says.
Is that page 79 of
Your
the essay?
evidence print out कर दो. DW and DW1 DW कर दियो sir.
Page 79, 80 of that.
Let us take out the printout now. Printout. I'll just hear, madam.
My lord.
Let the evidence of all the witnesses be called for. Okay. Printout करो दे दियो. After 10 minutes.
My-
After 10 minutes, let the printout. Yes, madam. They got that judgment. Where is that? You have the printout. You have the got the printout.
This
Yes,
is
them? Yes.
V. Manmat Rao. V. Manmat Rao also.
Print, that's what I'm saying. Take out the printout.
पठेइछे आपण WhatsApp.
Same judgment, na?
अभी मनोज राव
We should look at it.
आपण WhatsApp ରେ पठेइछे एटा काय? आणि WhatsApp केलं.
Just see whether I have cited some provision there. Is there any provision to that effect?
The judgment which I have given your lordship, that is cited here.
That is cited. Oh. Okay. That is cited. Okay. दे दीजिए तार प्रिंट आउट भी दे दीजिए पहले ठीक है एंड नाउ गिव इट टू मी जस्ट नाउ तो दीटा जजमेंट रहता ना दीटा नो both these things you send it okay I just come at Yes. Yes. Yes, madam. Yes.
The first point is that the IO is the informant, my lord. In that light, my lord may kindly
John Lee.
see PW9 statement. Prosecution witness number 9.
9.
He is the IO himself.
Okay. Yes, read it.
My lord, para 1.
Yes.
On 26/2/1996, I was posted as Inspector Vigilance Khurda. On that day, about 4:30 p.m., I, in presence of witnesses, conducted a surprise check in the premises of MS A.K. Sahu, wholesale dealer of kerosene oil in Baluga.
He's a wholesale dealer.
Pardon?
Wholesale dealer, huh?
Yes, my lord. And detected that
155 liters of
155
kerosene oil.
liters shortage of
So?
kerosene oil in his shop. Dealer was carrying on business beyond the permissible area. Hence, the stock was seized along with books of accounts. The stock with the container was released in Zimma of the dealer. Detailed memorandum was prepared at the spot along with weighment chart, stock verification report, true copy of stock and price declaration board, etc. And the memorandum was signed by the witnesses in token of its correctness. On my report to SP Vigilance Bhubaneswar, this case was registered and I was directed to investigate the case.
Yes.
He himself registered the FIR.
He himself registered the case and investigated also. Yes.
That case was registered on the date of raid, my lord, is on 26/2/1996. And the FIR was registered on 4/3/1996.
Okay.
No mention of the delays anywhere, my lord. 8 days of delay. 6 days of delay.
Prepare physical verification chart and prepare stock also.
My lord, the allegation that the informant, he has investigated and has come up with the allegation that 155 liters have been sold in black. That, my lord, that is my second point. The first point, I have only this much, my lord, because he himself reported the incident to the SP, and then he.
Yes, that I understood. Next, next point.
The next point is that about him, the appellant selling the kerosene oil in black, my lord.
PW?
My lord, for that, there is no instance where any PW witness have suggested that he was selling it in black. There have been no independent witnesses also who have suggested the same. PW1 in para 19 has said that.
PW1.
PW1.
Yes, read it.
I have not ascertained to whom the accused was selling kerosene in black.
Para?
Para 19.
Yes. Who is PW1?
My lord,
PW is the
Inspector Vigilance. Okay, come to para 7.
my lord. Para 7.
The IO says, the IO, the inspector, whoever it is, PW9 says 155 liters of kerosene were shortage.
Yes.
Isn't it? Now come in that context, CPW1 and para 7. Against the shortage of, read it.
Yes, my lord. Para 7, my lord.
Against the shortage of 1015
1015
liters of kerosene oil,
Huh.
dealer Ashok Kumar Sahu explained that
Stock of kerosene oil.
stock
includes
kerosene of
residence.
residence. So he proceeded
To
to
his
the resident,
residence,
and which is a
located at
distance
the
of 1 kilometer from the business premises, so and so. There we find the tanker in little so and so. We took so and so. Tanker is found. Thus, shortage of 155 liters of
Liters.
kerosene was noticed, and which was so and so. So 55 no problem.
155 liters.
155 is the shortage. Okay?
Yes, madam.
Yes. Next.
My lord, next is I'm referring to para 10 of PW1.
Read it.
The para.
Para 10. Cross examination.
Yes, ma'am.
Yes. No revenue document, no
document
revenue document relating to
to
the
place in
place of
business of the
business.
co-accused was seized by us.
Seized by us.
Why it is important, my lord? Because
So also the
so also we do not
procedure of
seize any revenue records relating to house premises of the accused.
post premises of the accused. I do not recollect any to last accused to show those revenue records. This is neither here nor there.
No, my lord, that's
Not
because
deciding title.
that is because PW4 has has said that both the Sabik Khata number 113 on that,
House and the shop is about 1 kilometer
my lord.
distance.
However, both of them would be under the business premises. That is because it is situated in one Sabik Khata number that is registered in the license.
But this witness says that it's 1 kilometer away.
It is 1 kilometer away, my lord. It admittedly is 1 kilometer away. However, it is registered under one Sabik Khata in the my lord.
Where is that? Which witness is saying that?
PW4 is saying that.
4 and 6. Let us see.
PW4, only PW4. my lord.
4 and 6. Let us see. Where the 4 says. Yes.
I measured the land basing on the record of rights of 1962 settlement. After 1962 settlement, there is no other settlement in respect of this particular moja till date. Till today, IO has not seized any document relating to title of Ashok Kumar Sahu in respect of that land in my presence. Business premises of the house and the house premises stand over two separate revenue khatas. I have not given the Sabik Khata number of the business and the house premise of the accused. I cannot say if the business premise and house premise stand over Sabik Khata number 113. That is because they have not seized.
I do not recall it. If I have stated before IO that the Sabik Khata number of both the premises 130.
130.
Yes.
Both of them stand on 113, my lord. That is why we are saying that the ones that are seized from the 860 liter that is seized from the residential premises that they are saying, that is also my business premises. Because in my license, I've mentioned that it is over Sabik Khata number 113.
So if it is your business premises,
My lord.
both the places, then what do you want to say? I will accept that.
First they were alleging that 1015 liters of shortage is there. Then, my lord, they're also alleging that I have kept the separate 860 liters in my residential premises, which I was aiming to sell
If
again.
that is factored into, then what is the difference? If 860 liters of the oil is factored into, then what will be the difference?
1015 liters of shortage will be there. My lord,
Anyway, shortage of the shortage is 155, no?
155, my lord.
No.
My lord, my point is that our business premises only held the rest of the kerosene, my lord.
That's what I'm saying. If I'll take both the premises are your business premises. They say that 1 kilometer away from your house, forget about that, because the evidence has come that in same civic plot, that is 113 civic plot, both the premises are there. Then I'll take it to be the same premises. Then what is the difference? Because see, what is the total recovery? What is the stock position? If the stock position of both the premises is taken,
is taken, and after that,
into, then is there any difference or not?
No, my lord.
No difference.
There is
Tell me the figures then.
My lord, 155 liter shortage is there. That
is the offense.
That is the offense, my lord.
Yes.
That can be. They did not see the closing amount of my register, my lord.
Where is that register closing amount? What does it say?
My lord, they have never mentioned the same. However, they have mentioned that there was one tanker that.
No, the register is recovered.
That is
exhibited.
That is exhibited, my lord.
Is the license. The annexure exhibit 1 is the display board. Is printed in
4100
The
liters.
display board shows 4,100 liters of stock charge. Exhibit can the digital page also 92 hours.
Yes.
Out of 4,100 liters, the expert statement of the evidence read by the tribunal, the 400 liters are also sold to the beneficiary.
Huh? 4?
400 liters only sold to
No,
beneficiary.
total is 4,000?
100 liters, Your Lordship.
4,100.
Yes, Your Lordship.
Okay.
Declared amount.
As per the sale register, as per the sale register, 400 liters only sold to the beneficiaries.
400.
Only, yes,
400
yes,
liters.
yes.
Then
And as per the.
1 minute.
Thereafter,
30,
after fourth,
then,
after.
then 39,000, 3,900 liters.
Should have been 3,700.
700.
37 লিটার হওয়া কথা যেহেতু 4,100 লিটার ডিসপ্লে ବୋର୍ଡ ରେ ରହୁଛି ଷ୍ଟକ୍ 400 লিটার ଗଲା
Okay.
ପରେ
Huh.
ଆଉ ରିମେନିଂ ରହିବା କଥା 3,700
700. Okay. Huh.
3,700 liters ତାର କ୍ଲାରିଫିକେସନ ଦେଲେ ୱେଟ ମେ ଯେ ସେ କହିଲେ ଯେ I have stock in my residence but license was made for the specified plot and specified plot, that is exhibit 8 your option. And exhibit 4 is the license. License was issued in respect of
In a particular premises.
Yes.
But what she says is both the premises falls in the same Sabi Kata that PW4 and 6 are saying.
That's it. But in the licensee, the specified plot has been mentioned, the Khata number so and so, and plot number 55 is meant for the licensee premises.
If the stock recovered from the house and stock recovered from the premises, business premises, the wholesale premises, both the premises are taken into consideration, is there any shortfall?
Yes.
What is that shortfall?
155 liters lordship. As per the PW7, the measurement.
In the display, what was shown?
Your Lordship, may I clarify?
4,100.
4,100 displays and shown in the cement board, Your Lordship. We have obtained the photo. 400 liters has been sold to the beneficiaries.
Yes.
Our remaining 3,700 should have been present.
Should have been there. And what was found?
At that point.
In both the premises, what was found? Tell me simple.
Yes, I'm just, we have, as per the weight and measure in the residence, we have got 2,605.
2,605.
605.
605, yes.
And another, Your Lordship, one shortage of 1,015, Your Lordship.
What was found in the house?
That's it.
What was found in the house?
In house, there we have found that 1,200,605 was loaded in a barren in the house, the residence of the present appellant, Your Lordship.
Are you sure what you are saying?
Yes, yes, I have given.
Tell me the figure, that's what I'm asking you. You hijack her argument
That is.
and tell me the figures now.
Yes, I am placing the figures, Your Lordship.
And you said 2,605 liters were found. Next, how much?
Next shortage of 1,015. Your Lordship.
860 was found in the tanker which was there, parked there. Thereafter,
After the, including these facts and after minusing 4,100 Lordship, 155 liters of shortage in the license, Your Lordship.
if this figure is to be taken into consideration, then 235 liters of kerosene oil was shortage.
That's what I am clarifying. 4,100 is shown in the display board, Your Lordship. And out of 4,100, 400 liters sold to the beneficiaries. Remaining 307 liters should have been given, should have been stocked in the business licensee premises. But while the institution team was asked to the licensee, he has replied that he has stock in another place in the residence premises. Agreeing with the institution team was accompanied to the premises of the residence premises. At that time, the inspection team was seized 200, 685 liters of kerosene oil, your lordship. Residence premises.
You said 2685 or 05?
2680, your lordship, I am not visible, 2685.
Yes, 85, okay.
There are the 1015 liters are the shortage.
1 minute. Yes, I got it. Yes,
Your lordship, 1215.
I got it. Yes, madam. You tell me.
My lord, there is also an error in the measurement as well.
No measurement, there is no error. I'll tell you why
My
it
lord,
is
the
there is.
way-
You said that, see, the recovery is from two places.
My lord,
One place is your stock where you have kept, that is wholesale place. From there it is recovered 2685 liters. Then you say that the rest of the oil is there in my house. They went. There a tanker was standing there. From the tanker, 860 liters of kerosene was recovered. If 860 plus 2685 is calculated together, then it comes to 3545. Okay. The stock registers, stock display shows
41.
that 3700, 3700 liters of kerosene oil should have been there with you as per the stock register and the display register. 3700 minus 3545 is equal to 155. That is the shortage shown.
Well.
So therefore the measurement has no issue. The only issue is the places, two places. Even if I accept your argument that both the places are same, how will you explain the shortage of 155 liters of kerosene? That's the issue.
my lord, I'd like to put just one more
I
point.
accept your argument that the SEBI Khata number is same. Therefore, both the places cannot be said to be at different places, the same premises. Okay, it's same premises. Even then, the stock found was 3545 liters, whereas the stock should have been 3700.
700. My lord,
There is a shortage of 155 liters. Yes.
my lord, just one point of consideration is that the means of measuring of the oil. If my lord may see PW 2 para 10.
PW?
2 para 10.
Yes.
120 liters measuring unit was used to measure the stock of super kerosene oil. He has mentioned here super kerosene oil. my lord.
Where?
Para
Para
10
10.
PW2.
Yes.
I cannot say who supplied that measuring unit. I do not know if the said measuring unit was seized. The kerosene oil was measured with the 20-liter measuring unit by drawing the SK oil through a pipe. I do not remember who sucked the pipe to bring out the SK oil from the barrels. No kerosene oil was overflowing the measuring unit at the time of such measurement. I cannot give the length or circumference of the pipe used to suck kerosene oil from the barrels. The pipe was not seized in my presence. After measurement of kerosene oil was kept in another empty barrel. After the contents were drained out, the empty barrels were shown to the witnesses. Each barrel will contain around 200 to 220 liters of kerosene oil. My lord, this statement and then the statement of PW7 in para 8.
1 minute. Yes. Para?
Para 8.
Of PW9?
PW7.
7. Yes. Yes.
I
9 you said?
I cannot say the number of
Para
barrels.
9 you are reading?
No, my lord, para 8.
8, okay. Yes.
The measurement units were not seized by the I cannot say the number of barrels present in the premises of the accused. There was no barrel at the residential premises of the accused. I cannot say the number of empty barrels used at the time of measurement. We have not used any pipe to draw kerosene from the barrels at the time of measurement. We applied gravitational method at the time of measurement of kerosene oil. It is not a fact that kerosene oil is usually measured by scientific method, but not by physical measurement.
Okay.
The,
Who is he?
my lord, he is
Assistant
assistant control
Meteorological
meteorology department.
Collector. Absolutely. See, another problem is this 860 liters of kerosene oil which was there in the house premises, that was measured. But the stock which was there in the wholesale premises,
That
is
was
not
not
measured.
measured. That is said by PW 8 in para 2.
Hmm?
PW 8 in para 2 says by the time of our arrival, we found one kerosene oil tanker parked within the business premises of the accused.
Para 2 of 8, 9.
PW 8 para 2, my lord.
Para 2. What does he say? By the time of our
Arrival, we found one kerosene oil
found the
tanker.
kerosene oil tanker parked with the business premises of the accused and his staff also present as per the direction of the I measured the stock position of the kerosene and with the assistance of the employees of the accused premises and business staff and the collector results on the measurement of the kerosene oil kept in 15 barrels, and it is found to be so kerosene oil and stock against the actual book balance of 3 so, and which was reflected declaration board, and in declaration board actual balance is 3 7. Yes.
That is the,
How much you have undergone?
my lord, 3 months.
3 months undergone.
3 months.
The probation. There is a problem in there is, it's not a case of acquittal.
Let me give me one more opportunity to appraise the lordship.
No, I'll give probation. See, I'll tell you, he has already undergone 3 months. And what was his age? I tell you, age was
somewhere around 50.
54 years in the year 2000. Now he's in 70s. I'll grant probation because why? The reason is you have sought for probation before the trial court, which was denied. I'll accept that. It's not a case for acquittal. Probation, huh? Already undergone about 3 months.
Yes.
Okay. Yes, next.
36.
Lordship, on behalf of Mr. Ekenanda, I may be permitted to place this matter.
Yes, yes.
Lordship, the appellant is more than 87-year old, Your Lordship. She is an old lady, 87 years.
87 years old.
Yes, Your Lordship.
What was his age? I believe
56, Your Lordship, at that time, 94.
How many appellants are there?
Your Lordship, she is not an accused in this case. Her vehicle was
Only one appellant, huh?
Yes, Lordship.
The vehicle is present.
Sorry?
Vehicle.
It is not in New York, but facts remain. The present appellant's vehicle was involved in this case, therefore.
Let us understand what is the case. What fact remains, I will see. What is the conviction under which provision? NDPS.
Yes, your lordship, 20B NDPS.
What is
Our vehicle was involved in this.
19 bags. 5 quintals. Sentence is about 3 years. There are 2 accused persons. What happens to the other accused? What about the appeal? Has he filed appeal or not?
Your lordship,
Appala Narasimha.
he is the owner of the truck, your lordship. He is not involved in the case.
So come to the impugn order. Come to the impugn order. This is fine. This is the first title. That is the reason why the name of the appellant is not there. See, 2 accused persons were there in the sessions court. Why the name is not there? It is name of the appellant does not find place in the cause title of the impugn order, impugn judgment, as she was not an accused in the case. However, as her vehicle has been directed to be confiscated, and which is revealed from the impugn judgment, she has preferred against confiscation, not against
Yes, your
confiscation.
lordship.
Okay. What happened to the appeal of these 2 accused persons, those who have been convicted?
That appeal is not in today's list also.
Right.
Whether that's referred to
Petitioner has challenged the where is the confiscation order? Challenge the impugn judgment. Which part is the confiscation? '93, this incident had happened. The truck was seized and confiscated. What is the position? Whether the truck is still there or not?
More than 31 years.
The appellant, the present appellant has assailed the judgment dated 8/2/1994. Judgment and order dated 11/2/1994, whereby 2 accused persons, namely while convicting 2 accused persons, namely P. Satyanarayana and A. Venkata Ramana, for offence under section 20B(1) of NDPS Act, sentence them to undergo imprisonment for 3 years. And at the same time confiscated the truck. Which truck is this? Confiscated the truck number ABK 799, 799, involved in the crime, involved in the commission of the crime. The present appellant is agreed by the confiscation. confiscation part of the confiscation. Hence, as I say, the judgment. The Land State Council, when a query was posed to Land State Council regarding the fate of the appeal filed by as to whether the convicted accused have preferred appeal or not, he has no instruction and no instruction. No instruction. It is also not clear as to whether the truck which was seized, confiscated, seized on 29/5/1993 is in existence or not. Let the State Council seek instruction regarding the same and report to the court on next Tuesday. Next Tuesday, report whether it is existing or not and what happened to the appeal up to these two agreements.
Online, yes.
Take the order, copy of the order we supply to the State Council. Tuesday, Thursday, next Thursday, 1 week. Okay, the appeal will be disposed of. Yes, next.
37.
Oblige you.
37. Also same.
Same.
Yes, my lords, it's a similar matter, my lords. Since and the brief belongs to late Shri Brahmananda Panda side, my lords. I pray if the brief
No,
transfer.
if the same thing, you are challenging that order because of the confiscation.
Yes.
What is the when was the seizure taken place? Where is the impugn order? Where is the impugn order? Impugn order, impugn order. When was the impugn order passed?
The order is
Then I find the name.
3/10/96.
1 minute.
The accused, the NTPS case, they involved, say, acquittal agent, so far, they, this is the NTPS case, they accused, say, acquitted. So far, the vehicle involved in the.
Then give it, acquittal.
That is there, Your Lordship, in that case, Your Lordship.
Acquitted?
Yes, in the findings of the foregoing paragraphs, I hold the accused.
Where are you reading?
Lordship, in the judgment, internal page 7, Your Lordship.
7, huh? 7.
I hold
The distance between the.
In respect of the accused after, there is
Which paragraph you are reading?
8, Your Lordship.
Internal page.
7 of the judgment.
Read right after registration.
In the findings.
In the fourth one.
Reading something else. File कोड़ा दीचो भाई.
37.
वो किस चीज़ है?
37.
अमियो केतन जना.
Yes.
अमियो केतन जना. Connected. What is this?
269. I am holding the brief 269. Your Lordship.
269.
Brief page.
269. Why 2 appeals, madam? Let us see. Who is the Amyo Kitan Jana? Excellency.
Amyo Kitan Jana is the.
Hearing, 1 minute. Hearing.
In second appeal, he has challenged the judgment as well as his petition for confiscation.
Release of the vehicle in his favor and was registered on also, but the learned court below was pleased to reject the same on the ground that the said petition is not maintainable as the original case has been disposed of after the regular trial and he was charged. Same connected matter. Okay. Oh, and show me now. Impugn order is which paragraph you said?
Paragraph 8, Your Lordship. 269 criminal.
Paragraph 8,
Lordship.
In view of my findings, that the foregoing paragraph, I hold the accused not guilty under so and so in the police case, and accordingly accused under section so and so. The seized car
engaged in
was
illegal
engaged in the illegal transportation of the ganja, and such is liable to be confiscated. Hence, the seized car confiscated
to the
stand
state.
and order seized and destroyed after the appeal. What is this? Appeal period. What happened? Have you preferred an appeal?
That
State
part-
has preferred an appeal.
That part I have no.
Then till appeal period it was there. We are thinking that state may appeal.
That part I have no instruction. So whether state has preferred any.
If you have not preferred appeal, then I'll allow it.
That part, ascertain-
After acquittal, the car was retained, saying that till the appeal period is over, then do it. The state might have appealed. You had already taken in Jima.
My lord.
Gadi ferry chund-
Then has it been recovered from you?
No, my lords, it has been, my lords, as per the soft copy, because we do not have the brief.
No,
with us.
read that part. Read
Yes,
that
my lord.
part.
Car
The
then-
seized car. Read.
Yes, yes.
Read
Since
it.
the owner has taken the car on Jima, the police be directed
Come,
to
why don't you read the full paragraph? The
Let-
seized car was engaged
in the illegal transportation.
engaged in the illegal transportation
of
of ganja, and as such is liable to be confiscated. Hence, the seized car be confiscated to the state, and the other seized articles be destroyed. After the
Appeal
appeal period is over, or in case of the appeal be disposed of as per the direction of the appellate court. Since the owner has taken the car on Jima, the police be directed to recover the car and from him and put it for public auction and deposit the sale proceeds also. Has it been recovered from you?
Acceptance in this regard, because the matter was listed back in 2012, my lords. And since Mr. Panda has passed, the brief may now be allotted to.
Shall I
the
presume that
deposition.
it is not recovered from you? Who has taken in Jima? The accused has taken in Jima. That's your grievance. It is, since the owner has taken, you are the owner, you are taken on Jima.
As per the order, my lords.
Unless you tell me that it is recovered or not,
36.
both the appeals taken. Chalo, I'll pass the order. Both the appeals. I'll pass dispose it out. This has to be allowed, in fact. But there will be no consequence whether the vehicle is recovered or not, nothing is known. Even if it is recovered, it says that it will be sold and
To that effect, I shall obtain the instruction from the local police, from the appellants, whether the vehicle has at that point of time has been seized from the appellant accused or not. in
day after
judgment.
tomorrow. Day after tomorrow.
Day after lordship,
If you
take some
give-
time, your lordship.
No, day after tomorrow you tell me, otherwise I'll allow it. This judgment, the judgment is completely illegal. It has to be set aside. It has to be set aside.
It next
Legally not sustainable order.
may pray your lordship let it come next Thursday because
Owner was not subjected to trial. It was some ganja was carried out, and the accused was put to trial. He was acquitted. And the meanwhile, the vehicle was given in the Jima of owner on the application of the court to the court. Once he is acquitted, it has to go to him. Where is the question of confiscation? Where is the question of confiscation? The accused is acquitted. And I can understand if the court would have said that, okay, till the appeal period remains. No, Jima was granted. The order is recover it from him and sell it. What kind of order? It has to be set aside. Day after tomorrow. I am reserving and no, day after tomorrow. The first item. Okay, day after. You tell me. And today only you take and get the instruction. Unnecessary, these matters are pending. Yes, both the matters will be decided.
38.
And in the second matter, what had happened is, instead of challenging that order, she moved in a fresh application before trial court, saying that since you have acquitted, release the vehicle. That was rejected, saying that no, I have already disposed of the appeal, so I will not pass the order. So that order also he has challenged. Second appeal was not necessary at all, but still, yes. Next.
38.
38.
Lordship, 38 one more opportunity instruction that it assi nahi lordship out din assu eta 38.
What is this? What opportunity?
Despite lordship, I have obtained the instruction, but the instruction is not clear. Therefore, lordship, I will obtain one more opportunity to get the instruction whereabouts regarding the appellants, lordship. No doubt.
The order dated 19/8 to 2025 has not been complied. And the State Council is seeking one more opportunity. Okay? 1 week after. Yes.
39.
39. Anybody is there? Have you got the instruction?
Yes, yes, instruction matter is ready for hearing, lordship.
Ready for hearing.
You sought time
No,
to
no.
get instruction.
But nothing is there, report already been filed, lordship, kept on recording.
But that proceeding is not there.
NDP is one there. NDP is one is coming.
Not PS. Not PS.
Not known, Ashwin
The
Midu nahi.
last two occasions.
Lordship, though instruction has been submitted, but whereabouts not known to the concerned police station, lordship, that is the report.
On 5/7/2025 and 31/7/2025, when the matter was taken up, none has appeared for the appellate. The IIC Barampur PS has submitted a report inter alia stating that the whereabouts of the appellant is could not be ascertained. The matter is ready for hearing. In the absence of any lawyer representing the appellant, I appoint day after tomorrow. I'm appointing you day after tomorrow. Day after tomorrow. Appointing, okay? My case, yeah? The president in the court. I would can my case killer taku de do madam matter sugila. Okay. What madam
item sheet.
I would killer. How she kete note कर दो ठीक है 40 कर दी 40 तक करके उठाया तब पूरी कर लिया ठीक है 40
Item 40.
Your Lordship, the paper book is not available.
paper book you have to take, madam. It will not be made available to you.
Your Lordship, I'll collect the paper book. I just need some. I'll collect the paper book. I just need
Soft copy. Learned counsel for the petitioner appellate submits that she doesn't have the copy of paper book and seeks permission to obtain the same soft copy of the same permission. Granted. Soft copy you take it and
Yes,
get
sir.
ready. Release the matter in the first week of yeah. All these are NDPS. Huh? Yes. Yes. And hearing 4 रे कौन अछि?
SST.
SC. चलो NDPS करियो. ठीक है 44 करियो. Okay. Yes.
This other matter listed today's work list, that's item number 93.
93.
93 man.
Yes.
I have hired. Now I have.
93 कर.
Of the state, have a humble request. That it needs a further oral argument. Your lordship is that is to a file.
I'll keep it on record and fix a date for. You tell me convenient date.
1 week.
I'll just see the date and give. Thank you. Continue. Pass over ଅଛି. ଦିଅ.
Item 19.
Pass over 19, huh? Yes.
Accused Rajeshwar Rao, along with 4 of his persons,
Evidence would have.
and Shankarsan Rao trespassed into the residence of informant Saraswati Behra at Aravind Nagar, Bangalore, and abused the informant in obscene language and indecent behavior. Accused Rajeshwar Rao assaulted her with it is alleged that accused Rajeshwar Rao assaulted her with an iron rod, causing fracture on her left arm. And seeing this attack on her mother, Sunita Behra, the daughter of the informant, she protested and tried to intervene. It is alleged that the accused persons they tried to manhandle her and also outrage her modesty. The accused has been convicted under 452, 325, and 506 year lordship.
3 convicted under section 452, 325, and 506. What is the sentence? 452. For every offense, there must be some sentence. You tell me 4.
1 year.
1 year, yes. Two months, huh? Okay. Undergone period? 16 days. Okay. Okay. Yes.
Informant's deposition.
What is your age now?
It's
Huh?
61.
61 years. Yes. Yes.
That
Who is informant? PW? PW4. Let us come to PW4. Yes. Read it.
present in the house at that time. But meanwhile, in her daughter's deposition, PW5, she has mentioned that she, along with her mother and 2 other minor sisters were present, who were not examined. The minor sisters were not examined.
Let's read that. Yes.
I know the accused.
Myself, my daughter, Sunita,
Sunita
were
Behra
there.
were there in the house at accused Boynath, Rajeshwar Rao, and Sankar Sharma entered inside my house. When I questioned them as to why they were entering into my house, They abused me in obscene language. It is quoted, Your Lordship. When I asked them as to why they were abusing me unnecessarily, accused Boynath caught hold of my hair, Shankar caught hold of me from my backside, and accused Rajeshwar dealt several blows with an iron rod.
So these two people were holding and Rajeshwar gave the blow
Yes, Your Lordship.
with an iron rod.
Iron rod.
As a result, I sustained fracture.
Your
And he is injured, huh?
Yes, Your Lordship.
Informant injured. Yes.
Your Lordship, may I also mention that no iron rod has been seized.
Let us read first. Let us
Yes,
understand.
After the incident, I was admitted in Medical College Hospital, Berhampur, and was treated there as an endo patient for 2 months. When I was there in the hospital, police officers came and I lodged that written report before them. This report was scribed by my son on my instruction, and after understanding the contents, I put my signature on the report. When the occurrence was going on, my daughter Sunita intervened, whereupon the accused person manhandled her. We belong to Dhoba caste. The accused persons belong to higher caste.
Print out. Evidence will print out. Yes.
Cross-examination, Your Lordship. I cannot write Odia, but I can sign my name. About 8 days after the occurrence, I lodged the written report with police. I did not lodge the report earlier as the accused person had threatened that they would lift my daughter away if I submitted any report to the police. My son was jointly living with us on the relevant date of occurrence. My son wrote the report and I put my signature on it. I was not able to read, so I do not know what exactly had been written in that report. She's contradicted her own statement, Your Lordship. On the very date of the occurrence, I was admitted in the hospital. I did not tell about the incident of attack on me to the doctor or of the hospital as the accused person threatened me. The accused persons are friends of each other. Sudhir is the brother of Boynath and is a friend of my son Arun. Sudhir used to visit our house at the time, but the accused person were not visiting our house. Sudhir and Boynath were not residents of our Sahi, but they used to visit the house of their sister who was living there. There was a marriage proposal between Sudhir and my daughter, but it did not materialize. I cannot say the name of the immediate neighbors. There was no house in front of my house. The assault and abuse took place inside our house. No outsider came when the accused persons abused and assaulted me. The iron rod was not very long, but I cannot say the exact measurement length of the rod. As a result of the assault, I sustained multiple fractures and injury on my left hand. I also received some blows on my back. There was a bleeding injury from the bleeding from the injuries on my left hand. My clothes were stained with blood. Police did not seize those blood-stained clothes as we lodged the report several days after the occurrence at the police station. I was examined by the IO at the medical after lodging the report. After the marriage proposal failed, we did not have any further relation with Sudhir. I have seen the accused person before the date of occurrence as they used to come to the house of sister of Sudhir. It is not a fact that the accused persons never abused me in obscene language, never assaulted me, never manhandled my daughter, and that we have created a story to harass them because we are aggrieved after breakage of the marriage proposal.
Yes.
Your Lordship,
Who is the doctor?
Doctor is PW1, Your Lordship.
CPW1. FIR incident on
13/11/1991.
13/11/1991. 91.
Yes, Your Lordship.
91. And FIR on
23/11/1991.
23/11/1991. After 10 days.
Yes, Your Lordship.
He was admitted in medical.
Hmm?
He was admitted in medical.
But he was admitted in medical for two months.
Your Lordship, in 5.
That is why the delay.
But delay is explained by PW4 saying that he has threatened.
Yes.
That I lift your daughter and all. So therefore, out of fear, you have not done it. Anyway, let us see, doctor.
On 14/11/91, I was a lecturer in the Department of Orthopedic in MKCG Medical College, Berhampur. On that date, the patient Saraswati Behera, while a wife of Raju Behera, of Arvind Nagar, Barampur, was admitted in the orthopedic department with multiple injuries.
She has sustained a very
Registration number 1075 dated 14/11/91.
fracture. Because time of examination is 14/11. Before the FIR was registered,
She was examined.
she was examined.
On 14.
14. Just see what he says. On 23/11/1991, the IO sent the requisition for medical examination of the patient, and I have issued the injury report. Exhibit 2 is the injury report. When she was examined, Exhibit 2. What is the exhibit? Take out the exhibits. A list of exhibits. See the Exhibit 2. Because at the top, he says that on 14/11/91, I was posted as a lecturer. And he says further that on 23/11/91, the IO has given the requisition. When he examined them,
On 14th, Your Lordship, 14/11/91 at 11 a.m.
how the requisition has given subsequently.
On 14/11, she was admitted. And on,
But the doctor says that on 23/11/91, IO sent the requisition to the medical.
for medical examination.
The FIR was registered subsequently on 23rd. How the without requisition, how this has happened? 14/11/91.
Indoor registration number is 1075 of 14/11/91. She was shifted by her son to the medical. Thereafter, on 23rd/11/2091, the IO sent requisition for medical examination of the patient.
What is written there? Have you examined these exhibits?
Pardon, Your Lordship.
Not the question also, the doctor, what is yours?
Your Lordship, in the cross-examination, the doctor has admitted that when the patient was admitted in the hospital, they reported the matter to the police on the same day, Your Lordship. That is supposed to be 14/11/91.
At the top it is written, had examined the patient on 14/11/91 at 11 a.m. The age of the injury was within 6 to 48 hours at the time of my examination. Exhibit 2/2 is the requisition of IO for medical examination. Where is that requisition? Exhibit 2/2. This is exhibit 2. It appears the the family members have taken her to the hospital on the next day, and the police in the cross examination, the PW1 says, we reported the matter to the police as usual on the same day. Police requisition in 23rd. Yes.
Your Lordship, may I take Your Lordship to the deposition of PW5, the daughter?
Yes.
She mentioned here in the PW5, Your Lordship.
Yes. Yes.
She mentioned in the first para 1, last 6 lines, Your Lordship.
Hmm.
She says that my mother tried to intervene, whereupon accused was dealing me with several blows. She intervened, whereas in PW4, she says that she was being dealt the blows and her daughter intervened in the matter.
Read it. Who is he? Sunita.
Sunita, the daughter. Only eyewitness, Your Lordship.
Read it. Myself, my mother were there inside the house.
I'll read it from the start, Your Lordship. Myself and my mother were there inside the house at Aravinda Nagar. At that time, accused Rajeshwar, Boynath and Shankar Saran entered inside a house and abused my mother in obscene language. When I protested about their behavior, the accused persons came toward me, and while accused Shankar Saran and Boynath caught hold of my hands and accused Rajeshwar manhandled me, my mother tried to intervene, whereupon accused Rajeshwar dealt several blows with an iron rod on my mother, causing fracture injuries on her left hand. While her mother says, PW4, she says that while I was being assaulted, my daughter intervened and then the accused persons manhandled her.
But the fact remains that she got injured.
Got it.
But Your Lordship,
Iron blow was given. Yes. That's a minor thing. And the doctor also says.
in her cross-examination, Your Lordship, she has mentioned that she was there with 2 other daughters that were not examined. So that is a difference in the statement, Your Lordship.
If the eyewitness is there, if the injured witness is there, informant is there, prosecution may not examine all the witnesses. If they could successfully prove through one witness, is it necessary that they should prove more? They must examine every witness. How will you doubt this PW 4 and PW 5?
Your Lordship,
Because that the statement are corroborating with the doctor's evidence. One thing is clear that the FIR was registered after 10 days.
Delay.
And the doctor has examined on the second day. 13th is the incident and 14th the examined. That time there is no existence of FIR. The doctor says that we have informed the police on the same day. That is on 14th. Even if 14th it was informed to the police, police has not registered the case. Police only registers the case on 23rd.
23rd.
And requisition is given on 23rd itself.
After registration.
That is the only gap. Yes.
There are other discrepancies, Your Lordship. May I show you? In PW4's statement, she has mentioned that when I was in the hospital, in her cross examination, Your Lordship, may
What contradiction?
she has stated that the police officers came to the hospital and thereby I lodged an FIR with them. Whereas the IO has stated that she came to the her son came to the police station and given a written
So
statement.
these are minor discrepancies. See, she was brutally attacked by you, and every family is attending the patient in the hospital. At the same time, she says that you have threatened not to register the. See the mental trauma. Minor, small variation here and there will not make difference. The overall thing, what had happened is you entered into the house, and two of your co-accused persons cut hold of the lady, and you gave a blow. You gave several blows in the iron rod. Okay? And that part of the story is consistent and which stands corroborated with the doctor's evidence. And minor who has written the FIR, what time it was read, all these things are minor contradictions. And and although the rod is not recovered, that's not recovered, and there is a delay in registration of the FIR. What else? Delay is also attempted. It is explained. You may accept it or not, but it is explained.
But Your Lordship, she's also denying that she doesn't know the contents of the FIR. At one time, she
says that I can't read Odia, but I can only sign.
She said that my son was
Conscious of the
remind-
fact, and it was exhibited. And where is the cross-examination to that effect?
Her son has.
in the cross examination, Your Lordship, she mentioned that she does not know the contents. In the examination, she said that on my instruction.
Either I can't. I don't know Odia.
On her instruction, her son has been scribed the affair. So this is not.
He says that I have narrated the things to my son, and son has scribed it.
So, but that is a very big discrepancy, Your Lordship. She's denying what is written in the FIR. Her son says that I read over and explained the contents of that report to my mother, and then my mother signed it.
You have undergone only 16 days.
Your Lordship.
1 year sentence. Day after tomorrow, read once again. You have a very difficult case. Read the exhibits also. Find out some loopholes, and because it's a difficult case for you, isn't it? Had it been an easy case, I would have straight away reserved the judgment.
Yes.
Prepare a note and come.
Obliged.
Okay?
Obliged, Your Lordship.
Let her do it. Huh? Read the exhibits also.
Yes, Your
Don't
Lordship.
leave it only PW you have read it.
Yes, Lordship.
Read the exhibits and find out what are the information. See, when they went on 14th
14th.
to the doctor, they might have informed how the injury has caused, whether they have complained, whether there is in the exhibit it is written or not. All these things has to be seen. Just check it out. Yes.
Obliged, Your Lordship.
28.
The instruction that was given.
Yeah, that 28.
However, the applicant could not be specific and sure the period he has undergone. Stated you will understand that in the year 19 he has undergone for a period of about 90 days.
Undergone.
Offense is 3 months. Sentence is 3 months.
Sentence is
3 months. Even the judgment is on 13th.
period already undergone.
Judgment is on 13/5/94, and from the High Court, he got the bail on 23/6/1994, after 1 month.
Sorry?
Judgment is on 13/5/1994, and from High Court, they got the bail on 23/6/1994, 1 month over here also.
1 month?
over here also, after the conviction, 1 month.
Acha.
More than the.
Total 4.
One more month will be added, huh?
Right. It is 3 months plus 500 just 3 months. Approximately 3 months.
No. See, the order is 23rd, 6/1994.
Yes.
On the petitioner surrendering before the so and so, he shall be released on bail. Because he was not taken into custody. He was not taken into custody.
No, I agree.
So this is the only period.
90 days is already under the 91.
$90 days.
90 days. I-
The period about 93 months. What is the sentence?
3 months. Euros.
Dispositive. Record. Petitioner, the appellant is agreed by the judgment and order dated so and so. Prosecution story is so and so. The prosecution examined so and so witnesses so and so. The trial court, after analyzing the evidence, formed the following conclusion.
Days 54 conviction.
1 minute.
Two months and 500 rupees. Before the 500 rupees, 2 months.
Para 10. Para 10, by finding the by recording the aforementioned finding, the appellant has been convicted for the offence under section 7(1)(a) small I of Essential Commodity Act for the violation of Order 13 of Orissa Rice Paddy Control Order and Order 14 of the Orissa either and wheat product control order is 10 drugs here, based 10 drugs. 13 to be 14, 14 for a 13 13 crore. Two parameters para 10, 8 and 10, 8 and 10. 8 and 10. For the aforementioned count, the appellant has been sentenced to undergo RI for 3 months And a fine of rupees 500 in default of payment of the fine. The accused was directed to undergo further arrest for a term of 2 months. 2 months. At the outset, legal counsel for the appellant submitted that he would press the appeal only limited to the quantum of sentence. When the matter was taken up for hearing on 1/7/2025, the following order was passed. Pursuant to the aforementioned order, on 9/7/2025, pursuant to the aforesaid order, IIC Fulwani, PS Town, has placed on record a report dated 9/7/2025, which reads as under. From the report, it is apparent that the petitioner, the appellant, has already undergone the period of undergone sentence for the period about 90 days. 90 days. In view of the aforementioned report, then the counsel for the appellant submits that the total period of sentence awarded against the appellant has already been served out by the petitioner, appellant. Hence, nothing survives, and she did not press the petition in view of the fact that the appellant was 33 years of age at the time of incident in the year 1992 and 1991, and at present he shows here regard being held to the same while maintaining the order of conviction, and the appeal is disposed of as the sentence awarded by the trial court. The appellant has already served out the entire sentence awarded by the trial court.
You're also 500 fine be there. 500.
And insofar as fine amount is concerned, the same is waived. Yes.
31.
Sorry?
This brief also belongs to Shri B. Panda, my lords.
This one?
Yes, my lords.
What is this matter in the order? Let's check it up. Then it can go to sentence is reduced to the period already undergone. The entire sentence is reduced to the period already undergone. Yes, madam. Repeat.
Here the conviction, there are two opinions. One of them has died, my lord, in the meantime, as per the noting.
Prakash Jana has died.
Yes.
And then who remains?
Duryodhan
Only
Patra.
Duryodhan Patro. What are the offenses?
7 of EC Act.
Huh?
7 of EC Act, Your Lordship.
EC Act.
Yes, Your Lordship. The present petitioner 2 is the owner of the truck.
Scanning ठीक कीजिए ना और तो पूरा इतना ही है file is also spoiled completely. Yes. And only the second appellant is there. What are the allegations against him?
The allegations against both the appellants was they were allegedly transferring and storing, carrying the alleged rice in question in excess of the permitted limit for the purpose of sale and merely because.
Yes.
That internal page 12, the judgment of the court below. It stated that the case of the prosecution is that on 9/5/95, the Assistant Civil Supplies Officer Khurda, along with Marketing Intelligence Inspectors of Khurda Block and Khurda NAC, had been to Khurda Bypass on enforcement work when they detected a truck bearing registration number standing near the oil.
31. Yes.
Standing near the oil Orissa premises loaded with CB rice, and on demand, both the accused person who were present in that truck could not produce any authority in token of purchase and transportation of such rice. for which the marketing intelligence inspector Khoda seized the truck along with the rice and the documents of the vehicle under a seizure list, and the weighment was found 61.61 quintals of rice and 140 bags was being transported in the said truck in contravention of Clause 3 of the Orissa Rice and Paddy Control Order 1965.
Yes.
The seized rice was released in Zima of one Manas Ranjan Patnaik under the Zimanama, and the documents of the vehicle were released in Zima of the driver. After completion of inquiry, the marketing intelligence inspector submitted the PR.
The entire judgment is also not there. Yes, madam.
Type କରିକି ଯାଇଥିଲା
Hmm?
legible କରିବା ପାଇଁ type କରିକି ଯାଇଛି
Nothing is there.
the finisher not legible therefore type copies and file
What is the sentence?
sentence your lordship
The sentence is six months, my lord.
Which one? The age of the Duryodhan age. Duryodhan age katu. 38. 99, 38. $95. When was the seizure taken place? $91.
Same date, my lord. 9595.
Huh? Commission of offenses 95. 95 the 28th level of the test the full. Yes. What is your defense?
It's the plea of the of the appellants during trial was that they were just transporting the rice and it belonged to two of the farmers, namely Vijay and Satyanarayana.
Notice was issued to them.
Right.
Both what is their name? Their name is
Vijay, Satyanarayana.
Satyanarayan, Budhya Behra and Satyanarayan. The notices were issued to them and they didn't turn up. Where is your statement? Duryodhan, when the notice was issued to you, Prakash has died. The recovery was made from Prakash.
Right.
You are not nowhere there in the picture. And the vehicle belongs to you.
Yes, ma'am.
When notices were issued to you under section 727, and you said that this rice belongs to two of them, and these two people were also noticed, and they didn't turn up. Then the prosecution report was filed and the prosecution initiated against you. But in 313 statement after the evidence was recorded, you have said that the truck was taken on rent. I had no idea what was being transferred there. That is what your stand is.
Right.
Let us see the evidence of the witnesses now.
W1. Has not supported the prosecution story. He says that nothing was written at the time of the signature. He was signed on the blank paper.
Yes, what is the evidence?
Also for the PW2 and the 4, is the marketing inspector intelligence.
What they have said, they've only said that they've received from Prakash.
Yes. that
And
is
then how we are talking about Duryodhan? Prakash has already died.
the-
What are the evidence against Duryodhan?
Duryodhan is the owner of that vehicle,
Merely owner.
at the time of seizure and could not produce the
Where
document.
have you said the owner? Where have you produced the ownership?
See, he clearly admits that I am the owner.
Acha, accused admission, you will convict him. Show me the evidence. Show me the evidence that the vehicle belongs to Duryodhan.
That part is evidence nowhere mentioned.
Then
but
your court case goes.
Time pass for a moment also. But the appellant very much fairly admits that this only I am the owner of the truck.
Suppose you admit that you have murdered someone, you will be
I am
convicted.
saying, he clearly admits I am the owner of the truck. I procured the said alias quintal of petty.
What is the evidence you brought on record?
You that part you also, but nowhere in the evidence regarding the owner.
The story goes like this.
Yes, sir.
In one truck, one Prakash was carrying some rice.
Yes, sir.
He was apprehended. And license was demanded from him. He said that I don't have license. Even he doesn't say that the vehicle in which he was transporting belongs to Duryodhan. Subsequently, you inquired from investigation, whatever you have done, you issued a notice to Duryodhan. Duryodhan says that I was not carrying it. I was in the reply. The reply is not even exhibited. The reply you have not exhibited. Only say that it was belongs to one Satyanarayan and some Behra. And as a transporter, it was transported only. That is what his version is. And 313 when you asked, he said that the truck was taken on rent. Except that, what evidence you have? I read full file.
Yes, Your Lordship. I am.
Do you have anything?
That substantially, Your Lordship, story, Your Lordship, whether the verify the ownership of that vehicle, that President Captain.
You have to prove that this vehicle belongs to him.
But
You can't ask it whether the vehicle is yours. If the accused says yes, my vehicle, then convict him.
Authorities issued notice to the from the attribute.
Where have you exhibited that notice?
That document is not
Then
exhibited. But that is the very admit
you
that-
may make out any story. Where is that notice? You show me. Where is the reply? Where have you brought that reply on record? To that extent also, I will be agreeing to you with you. In that reply, if you have said I am owner, even if on that basis you can't convict, you should have independent evidence. Has he pleaded guilty? Has he pleaded guilty? As if you are saying he pleaded guilty, so then you have to prove the case beyond all reasonable doubt.
But fact remains is clearly admit that I am the owner of the vehicle.
Fact remains that you don't have a case. That fact remains.
If he admits he disputed that I am not the owner of the vehicle, then it is guilty upon catch upon.
Oh, that is the standard of proof you expect. Huh?
No, I am not the owner. They have given the notice.
So why is the trial then? You ask the accused whether he have committed murder. If he'll say yes, convict him. Why the entire trial, investigation and all these things is not required at all? If I accept your argument. You asked him whether the truck belongs to you. He said yes, therefore convict.
Verification of Sibo. The notice is issued to the president.
Where is that evidence?
That evidence is not been
Then
executed by the entire court.
I will presume that RC book. Where is that evidence? In the entire prosecution evidence, have you put that have you brought on record the RC book or the notice which you have issued? The reply which has given by him, nothing is there. Show me, read that part. Chimanama, all these things. Nothing is there. See the list of exhibits. Where is it? seizure list, Jimanama, seizure list, all these things. Neither the notice issued by you to Duryodhan, nor the notice given to the two agriculturists, those who have not replied to the notice, none of them are there. Let us give a DTC reports. No, this one, I will get it. Leave it, otherwise I'll forget. Chalo.
Unborn substances can become the exhibit, digital page or 46 hours.
Exhibit.
Can become the digital page 46 hours.
Huh?
Yes, exhibit, yes. Digital lecture also. One page also, along with one prop register of so and so, being session relationship, number running condition, owner of the decision partner also. That is there on record.
You have written it.
After verification, they ask you.
Where is that evidence?
Is this
Seizure list is only
part, the list also is part
the right. Seizure, I will see the seizure list and prove. I'll take it that the vehicle is. Seizure list is only meant that the rice was seized. That seizure list was prepared.
Along with the regular also after that is
See,
there
you are the prosecutor. You make statement responsibly.
that
It's a matter of convicting someone. Don't say all these things.
here of the owner of this property.
Where show me RC book. Where have you exhibited? Not there. Then what are you asking? You ask the accused himself whether this vehicle belongs to you. He said yes, and that also you have issued a notice. Notice is not exhibited. The reply is not exhibited.
I am not saying. At the time of
You are not saying, the accused is saying. That's what you are saying.
at the time, seizure, the RC book can deal from the vehicular seized. After verification.
Where is that RC book? Where is that? Show me. Where?
Not been exhibited, but similarly it was mentioned.
What are you saying? This will not help you. Even if the vehicle belongs to him,
Yes.
merely it was transported by someone. Unless you link, how will you convict?
They have not been examined. Since you go to the agriculture division, they have some instruction to protect and see Dhanwanti to be photography not been examined by people don't try so they whether they come forward.
Who will examine? Accused will examine.
You know that is the I not accused to bring on this they are not
First you see before I just 1 minute before I say it, before you open your mouth, being the prosecutor, make the statement responsibly. It is who's responsible to prove the case beyond reasonable doubt? Then why have you not brought these two people as a witness? And from their mouth you could have extracted, no, this rice not belongs to me. Have you done it? You want that they will prove it. They will have to prove negative. What do you? Yes.
34.
Okay.
Yes, 34. Yes.
I got this matter, from some other day. But I am going to LCR, I don't have any.
Offense?
Offense, under section 7 of the ACR.
Wow.
Service.
The experience you have, I don't think it will take. From there also you can read and argue. What? What is
Here was
sentence? 3 months, 6 months.
3 months. Only, I am only concerned with that person still in service.
You are aiming at an acquittal.
I have to get ready in this case.
So day after.
Without sanction.
Day after.
Day after tomorrow, I am not available. So that's the reason for the 30th that will convert me. This Thursday and Friday, next Thursday and Friday, I am not.
Okay. Okay. So prepare a small note then. Who is he?
This person,
There are two appeals. There are two appeals basically. One is Sudhanshu and other is Saroj Kumar Pradhan. Saroj Kumar Pradhan. You argue for both. Forget about whether he is there or not. Argue for both. I will appoint you as M.A. Kishpuri in there. Argue for both. The other one is not. Both the appeals, huh? 30th, prepare small note and get it. Yes. You give soft copy to me. Soft copy. You take the soft copy. Please do it. What's it? ये हाँ? देखो एज देख लियो ना, एज देख लीजिए ना पड़िए. No, he is alive. There are two accused here. Narahari Mohanto died, and Saroj Kumar Pradhan is alive. Is alive. How many accused are there total? Let's see.
3 accused persons are
Four, 5 were there. 5 were there.
5%
So,
first trial, out of that 3%.
You are for Sudhanshu only.
I presume.
You argue all the arguments. Give the soft copy. Take soft copy and get ready. Yes. Anybody is there to argue any matter? Ready? Otherwise, I'll be taken. Huh? Okay. Anybody is there? Any matter ready? So that we can hear. Otherwise, I'll go and give dictation. 57. 47.
Is there confusion, my lord? Last time I accepted my that the government servant is or small.
Yes. Yes. When the charge sheet was filed?
It was filed, my lord,
It was 94, na? Anyway. Sections, rule 7 is compliant. The rule 7 was not there that time. 95. Yes. Yes.
The refer is 341, 294, 323, 506. Case and counter case was there, I will go, but that counter case was a drop since it was lost, the latter statement. That's why counter case, that was this record review that was Bansi's case, compensation. By filed by the present appeal. But I am on the FIR, you also find that FIR matter. The FIR that is no allegation of a statement. That's it. So I have no detail I have stated in my notes.
Let us see, let us read the note itself so that we will get an idea. Then we will proceed. Let us read the note first.
Fact of the case.
Understand the thing. Facts, huh? On 16/1/1993 at about 4 p.m., while the informant PW1, the Sarpanch of so Gram Panchayat was coming on a the chief of who are you?
The petitioner is a postal working at the post office.
Postal copy. Also deadlift fees follow. They will also threaten by saying it would kill him in Gundas from Burampur side and thereafter brought us to the police station and reported the matter. In order to prove the procedure, 6 witnesses. So and so. And defense, what is the defense stand? Stand up for the appellant is one of the people not up for the appellant. So when the informant was returning to the weekly market for evidence card भैया evidence card छोटा छोड़ना चलती 6 witnesses.
For this six witnesses, PW, who is the doctor? PW, IT is the investigation officer. For 1, 3, and 3, 4, and 6. Out of them, 4 turned hostile. 1, 3, and 6 evidence is relevant.
1, 3
And 6.
yes. But let us see what are the submission you have. Submissions are the presentability charge and 3 charge was framed again. 323 so far as so as he is concerned, the FIR the involvement is now released.
I'll witness.
Yes. What are the utterances? Dongo Sarpanch. In the FIR, what was the allegation? Assault only.
ମୋର ବେକ ପୋତିକି ତଳେ ଲଗାଇକି ମତେ ଅଜସ୍ର ଲାତ ବିଧା ମାଡ଼ ମାରିଲା ଏବଂ କହିଲା କି ବ୍ରହ୍ମପୁରର ଗୁଣ୍ଡା ଆଣି ତୋତେ ଜୀବନରେ ମାରିଦେବୁ।
Where is the FIR? Let us see the FIR.
Doctor, no such English is there, only one.
He doesn't say anything. Gali deva katha he would have.
So, that we don't want that. We don't want evidence. I know the acting belongs to one with the residential shop. He is also government dealer of essential commodity.
But he doesn't say Dombo Panchayat and all. He doesn't make any allegation regarding the.
My cycle and returned me. Then I got down from the cycle. They accused controlled me both hands, abused me. 80 koila that Dombo valley koila.
That is in evidence, he says.
Evidence.
Let us see. In the first FIR, nothing is said.
80 says. Dombo so saying he controlled my leg and fell me down. Threatened saying he will kill me by bringing Gunda Barampur. No actual body is there.
Yes.
Cross-examination, I have also marked that height.
Let us see now the evidence. PW1.
There is pura actual pattern on my web. We are talking about this. And
Yes.
we also can come to page 3, para 5.
Page 3,
Para 5.
para 5. Yes, CD.
Actually, also postmortem.
No. You are reading evidence. PW1.
PW1.
Yes. PW1 para 5 starts Baidyanath Puntiya.
4 lines, actually.
4 lines. At present he has gone outside. The accused is also postmaster. The accused is also a postmaster in the village. The accused was standing by the side of the road and seeing me came in front by cycle on the road. And while he saw the accused, he was in the hotel of Baidyanath along with the other. Seeing me, he came out of the hotel and stood by so-and-so road. I told the accused that I have no fault. And since the villagers gave me the complaint petition, I simply forwarded them to the video. I cannot say for how much time the occurrences took place. I have not mentioned in the FIR and before I have not mentioned in the FIR and before that I was going near my cycle and the accused caught hold of handle of my cycle and obstructed me. It is not a fact that I have not stated before the IO that the accused abused me saying so and so.
But that SC/ST party is not there.
Not there.
He had accepted that in the.
I have not, it is not a fact. That means it says that it is not a fact that I have not stated. That means he has stated.
No, it is a fact there.
Hmm?
It is a fact there.
No, it is not a fact that I have not stated before the IO that the accused abused me saying so and so.
Fact there.
I print out करायची.
Take it out of the custody.
अभी तो प्रिंट आउट आपण सामने करी दो.
नाही त्याची खबर घेऊन. हो जातो. ते रेडर मार्क.
I have not mentioned in the FIR so and so so and so. ତା ତଳେ ଅଛି ନା?
It is a fact that I have not stated.
Before police ତା ତଳଟା ପଢନ୍ତୁ ନା. It is not a fact that I have not stated. Just see. Read the line. It is not a fact.
Told me Sarapanta again not uttered any abusive word. That part is what this.
No, ତାର ଆଗରୁ ପୁରା ପଢନ୍ତୁ ନା. It is not a fact that I have not stated before the IO that accused abused me saying so and so so and so. अरे आपण देखନ୍ତୁ ଆପଣଙ୍କର ଦେଖିକି ସେମ୍ ଜିନିଷଟା ପଡୁଛି ଫ୍ୟାକ୍ଟ ଲେଖା ହେଇଛି. Not a fact ଲେଖା ହେଇଛି.
Not fact that.
It is a fact that I have not stated. तापर ଲେଖା ହେଇଛି. It is a fact that I have not stated before IO that the accused also uttered. These are contradictions. These are contradictions. And it is not a fact that the accused Sarpanch told so and so is not uttered any abusive word. It's not a fact that the deposed falsehood so and so so and so. It's not a fact that violence also. But 80. The word 80 କହିଛି କି chief ରେ କହିଛି କି chief ରେ କହିଛି.
ଫେର ନଥିଲା ଇରେ କହିଲେ ତ ସେ ଆଡମିଟ କରିଥିଲେ ମୁଁ କହିନା ବୋଲି ଦଣ୍ଡ ପାଠ ଯେ ଫ୍ୟାକ୍ଟର ଏଫଆଇଆର
But if you read both the part,
I do file case ଟା ବୋଲି ସେଟା ସେ para 4 ର what ଆକାଡ କରୁଛି
para 4 ର
para 4 page 4 minus page 4 ସେ para କମ୍ପ୍ଲିଟ କରୁଛି 6 paragraph ଟା. It is a fact that acting filed a case against me and I am on bail in that case.
it is not a where are you reading?
That is
It is a fact that the accused filed a case against me. It is a fact that the accused filed a case against me and I am not I am on the bail in that case. In the court of Lakshmipur. It is not a fact that there was a case pending against them.
And subsequently another day he examined and that day only he produced that is page 5 में राशि. I brought exhibit 3 yesterday from Tahsildar, that's cash certificate. Para 7 रे page 5 para 7 रे 1890 पर जो एग्जाम लेती से इधर के कास्ट सर्टिफिकेट पर आने की अच्छी.
Where is that? 7. Which?
Page 5 से P1 evidence for अच्छी. P5 examine the recall that 19 to 94 से इधर से कास्ट सर्टिफिकेट विषय डोंबो का.
I am filing the caste certificate issued by the Tahsildar showing that I am a Dombo by caste and it is a certificate execution of after objection of late so and so. I have again re-object again. I have bought exhibits also yesterday from Tahsildar. After the date of my evidence in the court, in the case, I applied for the certificate copy also. 8 days after the certificate was issued to me, the RI has inquired about the so and so. What do you want to say there?
Suppose he has no not stated that Dombo.
We not stated before police, not stated before in the FIR. That's right.
Subsequently, his certificate was not there at the time of crime or subsequently also, in date of evidence, subsequently arrange the certificate.
Getting a certificate is not important. Next, any other evidence? Yes. 2 years.
He is the doctor mentor. He has said one abrasion and one and complaining pain. It's not is the but 323 is concerned. So for allegation is concerned, that is there is contradiction. So how he happened to work?
PW3.
This was last line. So told him saying this part is not stated by PW1, it is regulated by
Who is PW3? IU?
E and 6. Both are IUPs.
this part, but PW1 said, he has stated something different than PW1.
Hey, who is PW3?
PW3, one of the witness that
He's a villager.
villager. Supporter of the PW1 is Sarpant is a total of the also.
But he says that
The poor Sankar Mishra, and no PW1 is not.
he is saying something else.
Something else. And also the astral part we also so he developed that part and his astral part is but he said that is no such injury is also there.
But what PW2 says?
Two only say two that I have
One aberration, one.
only one happened and complain of there. There is no mark of prosecution or something. I have not seen any mark of injury on the chest of the injured. To quote, there is no nail mark on the abdomen. The injury can also proceed by fall. You know, cycle अटके देला तो कहीं पड़ी गई हुई थी.
PW4? PW4 hostel.
I think that I have prior to that, I have not PW6 is another occurrence.
6, huh? What does he say?
He also stated some not like PW1 and 3. This is the allegation is something more than
PW6, huh?
PW6.
What does he say? You say, no? Saying he's adding something. Then PW, who all are the witnesses? PW1?
1, 3 and 6.
1, 3 and 6.
2 is doctor. I think
PW2, doctor.
I think
I witnesses.
4 are hostel.
PW4 hostel. Okay. In the FIR, he says something else. Let us see 313.
That yes, of PW5 he has been confirmed about this development minor. She kind of phase 2 para 4 is the fact that PW3 has stated for me that the internal director approach the accused has not stated before me that the accused after
It's 313 to print out. Yes, madam, what do you say?
And also that question not asking 313.
I saw 330. Yes. That in the See in the FIR, the same informant PW1 has not said a single word regarding taking the name of the caste and all. Nothing was said. Once he comes to the witness box, he improvises, says that Sarpanch or Dumbo and all are scolded. Okay? First introduction of section 3 and all. And PW3, the expression used, alleged to have been used by him, is again improvised. And PW6 again added 2-3 words there. And if this is the improvisation, in 313, every sentence uttered by him, taking the name of the victim, the caste, abusing in the caste name, has to be put to the accused. Just in 313, nothing was put. And the same PW1, he gives the FIR. He doesn't say anything. And in 313, question number 13, a detailed explanation is given. There is an FIR registered against him. So therefore, past enmity. So therefore, he has been, falsely implicated. When the suggestion was put, he says that neither in the FIR nor I have told all these things to the police, to the IO, in this suggestion. Give in writing, whatever you want.
I may pardon your lordship.
Yes, sir.
Item number 65. Can it be possible for your lordship to take it as a first matter after lunch?
Tomorrow, day after? Day after, Thursday? Thursday, 3 o'clock? Thursday, 3 o'clock. Yes, sir, you have some.
Number of cases, it will be taken up.
And all EC Act and the small matters. I have
Section 3, which by arrangement was obeying, my lord has also decided a case, an Ajay Singh's case that is there, where squarely comes his case also.
Then give that judgment. The photocopy of the photocopy. Can I keep it? You get one. And this you section 3 and all, this is invariably misused.
I brought it because the case which I am supposed to be argued in this case, Criminal Appeal 199, same point.
Then Thursday?
Thursday.
Before lunch you do it.
Yeah.
Same point. Give the same point. I can add that also. What is the problem? Which paragraph? No, same. Or improvise. Particularly if the victim himself is the author of the FIR, He should have said something. Nothing is said. It agree with you. Okay, thank you.